it's a technical issue, and a philosophical one. And so we really are asking you to sort of roll up your sleeves. We already have somebody who has rolled up their sleeves in the room, to roll up your sleeves and help us work through the issue today. So I'm really hoping that we have a good conversation, and I'm so excited that so many people were able to join us today. The one thing I will say, I have a hearing impairment, so I've got my hearing aid in today, but I would really appreciate if everybody really does use that microphone, so because I'm sure that I'm just the only one who's vocalizing that they can't hear things. So make sure that you do use that. That helps the people that are also viewing this later understand the discussions that we had here today. The only change to the agenda is we're going to take the break a little earlier. So our facilitator today will be Kevin Reitz, who is a professor at the University of Minnesota Law School. I'm going to tell you about him in just a minute, but he's going to probably take a break about halfway through the facilitation, and then we'll come back, and then we'll move into public comment after our full facilitation. Just a word I want to say about Professor Reitz. We are incredibly lucky to have him here today to facilitate this discussion. Professor Reitz has studied sentencing guidelines almost his entire career, and in fact, he is responsible for the creation of the National Association of Sentencing Commissions, because one year when he was a young professor, he decided to bring all the young emerging commissions together so that they could share information and talk to each other. And that led to the creation of the National Association of Sentencing Commissions, which is a really invaluable resource that meets annually. And we get to talk to our partner jurisdictions, our partner commissions across the country. So we've got someone that goes way back in the history of how guidelines work and really understands them, helping to facilitate today. And I could not be more grateful for you coming in to help us with this issue today. That's it. Literally, I'm not going to say anything else as chair. I'm just going to be a participant from this point forward. And I will turn it back over to Nate Reitz to take us through the background presentation. Thanks again for coming.
Thanks, Kelly.
I was going to do intros. So let me just I was going to lead that. So let me do that. We have to find out who's in the room, right? So let's just go around quickly. Sorry, I'm nervous. Like, this is big. This is a big day, and I'm excited for the conversation. So I get nervous too. Let's just go around the room. Everybody, I'd like the folks who are on the commission just to say your name and what position you're filling on the commission. So I'm filling a public member position. That's the position I was appointed to fill. So I'd like to hear that. And then for the folks who are not on the commission, just your name and the organization that you're here to represent. So I'm going to go to our vice chair, Valerie, first.
Good afternoon, everybody. My name is Valerie Estrada, and I am filling the probation officer position chair.
I'm Kyra Ladd. I'm the Wadena County Attorney, and I am filling the position for the County Attorney representation on the commission.
My name is Brooke Morath. I am also a public member on the commission and a victim representative.
My name is Catherine Johnson. I am not on the commission. I'm the current director of Hennepin County Community Corrections. I'm here today as the president of the Minnesota Association of Community Corrections Act Counties.
My name is Athena Hollins. I am a representative in the Minnesota.
Good afternoon. I'm Dave Zimmer. I'm a 33-year veteran of law enforcement in the metro area, retired, and I sit here representing Center for American Experiment. Thank you.
I'm Nate Reitz. I'm the executive director of the commission, so I'm not on the commission. I run the staff of the commission.
My name is Artika Roller. I'm the executive director of the Minnesota Coalition Against Sexual Assault, representing 66 member programs across the state of Minnesota.
I'm Paul Schnell. I'm on the Guidelines Commission and serve in that capacity as the Commissioner of Corrections.
Hi, I'm John Chitwood. I'm a board member with the Minnesota Association of Criminal Defense Lawyers.
Hello, my name is Mohammed Ibrahim. I am a peace officer, and I'm filling in the peace officer vacant position.
Hello, everybody. My name is Gordon Moore. I'm Associate Justice on the Supreme Court, filling the position that the Chief Justice holds on the Guidelines Commission. Before coming to the court, I was a lawyer, county attorney, and district court judge in Southwest Minnesota for 25 years.
Good afternoon. I'm David Knutson. I'm a district court judge down in Dakota County and serve on the commission and practiced law prior to being appointed to the bench. And prior to that, and part of that time, I served in the state senate. So,
hi, my name is Robert Small. I'm the executive director for the County Attorneys Association.
Hi, I'm Catherine Middlebrook. I'm Chief Appellate Public Defender, and I'm a commission member representing the public defenders.
Well, I'm Michelle Larkin. I'm on the committee.
I'm Kevin Wright, so I'm on the law faculty of the University of Minnesota. Glad to be here.
All right, thanks, everyone. Now I will officially turn it over to Nate.
Thank you, Kelly. And I should add also that the cookies and coffee are not going to consume themselves, so I will not be at all offended if during the presentation you get up and help yourself. Also, if you have any questions during the presentation, I guess, I don't know if you, we're trying to make it pretty quick, but I'll be happy to stop and answer any questions that you might have as we go along. So this is kind of orientation we're not assuming a particular level of knowledge. Now, some of this will be pretty high level, and I apologize for that, but I know we've got different backgrounds here. We're going to be talking about 4 different things. One is just a very, very big picture overview of the sentencing guidelines. The second is talking about this historical review that the commission did a few years ago on the criminal history score, and then kind of narrow. So we're kind of getting narrower focus. We're finally getting to the 1/2 custody status point problem, which is really what brings us here today. And finally, we'll be looking at some data on how custody status is applied. But let's begin with that sentencing guidelines overview. So the different principles of that the commission has used in crafting and originally promulgating sentencing guidelines and making amendments are up here on the screen. Public safety has been given to the commission by the legislatures being its primary consideration whenever it makes changes to the sentencing guidelines. Other things that the commission looks for are uniformity, the principle that people shouldn't get a different deal depending on who they are or where they are in the state. Predictability, the idea that consequences have predictable responses. Rationality, the idea that the guidelines make sense. Proportionality, the idea that the punishment fits the crime. Neutrality, the idea that you don't, like I said, with uniformity, you don't get a special deal depending on who you are. And capacity, the idea that correctional resources are not infinite. We have finite correctional resources, and we should use those limited resources in the wisest way. So looking at two of those, uniformity and proportionality, the idea of uniformity is that people with similar criminal records and similar types of crimes should get similar sentences. Proportionality is sort of similar. Criminal history and offense severity should determine the severity of the sanction. The worse the criminal history, the higher the sanction. The more severe the offense, the higher the sanction. And you'll notice those inputs have some similarities, right? You have both the criminal history of the defendant and you have the severity of the offense. And those two inputs really are what make up the sentencing guidelines grid. There are actually 3 different grids. This is the standard grid here, and it's got 2 axes, and those 2 axes represent those 2 different things that we were just talking about. One is the criminal history of the defendant. That's really intended to be the secondary factor in determining the sentence. The primary factor is the severity of the offense itself. And the axis goes from least severe on the bottom to most severe on the top. And likewise with criminal history, no criminal history on the left, higher criminal history on the right. And it tops out at a criminal history score of 6 or more. And we'll talk about what makes up that criminal history score in a moment. But I just want to point out how the grid works. There's a shaded portion of the grid and a non-shaded portion of the grid. The shaded portion of the grid means that the recommended sentence that the sentencing guidelines recommend for that particular person in that particular case is a stayed prison sentence, up to a year of local jail time, but the prison sentence should be stayed. There shouldn't be an executed prison sentence unless there's later a probation revocation. The non-shaded portion, however, sorry, I think I just rested my palm on the mouse pad. The non-shaded portion means that the Minnesota sentencing guidelines recommend an executed sentence. And the duration in there is the number of months that the sentencing guidelines recommend, as well as in italics, a range that the judge can sentence without departing from the sentencing guidelines. So that's the sentencing guidelines in a nutshell. So just to zero in an example, let's take a defendant who commits a home burglary. That's ranked. So the severity of that offense has been determined by the commission to be level 5. So that's severity level 5. So it comes in at the row that's marked 5. This particular person, so that's the offense, and now we look at the defendant. This particular person will say has a criminal history score of 3 due to prior felony convictions. So you just get the intersection of row 5, column 3, and you get the box that says 33 months. And because it's not shaded, that means that the presumptive disposition, so the duration is 33 months, the presumptive duration. The presumptive disposition is commit to the Commissioner of Corrections for 33 months. So that would be the presumptive sentence, a commitment to the Commissioner of Corrections for 33 months. The judge would not be departing from the sentencing guidelines if that were the sentence imposed, nor would a sentence of as low as 29 months and as high as 39 months. Those would all be within what is permissible by the sentencing guidelines. And you can depart from the sentencing guidelines, but the judge has to articulate substantial and compelling reasons why that departure is appropriate in this case. So let's look at the criminal history score. That's the horizontal axis. That's looking at the defendant, not the offense, but the person who committed the crime. So there are 4 components: prior felonies, and that's the one component that doesn't really have a limit as to how many you can get. You get as many as you have prior felonies, basically, and each felony can be worth a half a point, point and a half, or 2 points, depending on how severe that prior felony is. And all those, as I said, all the prior felony points are added together, and they're totaled. Now, this will come up later. The sum is rounded down if it's not a whole number, because the horizontal axis of the sentencing guidelines sentencing guidelines grids only contains whole numbers. So, and I should say, if it goes above 6, then that's basically maxed out. The far right column is 6 or more. So you could have a criminal history score of 12, but it wouldn't make a difference between a 12 or 6. The next component is prior misdemeanors, and you only have 1 point possible in this, and that 1 point would require you to have 4 prior misdemeanors. They have to be either targeted misdemeanors, non-traffic gross misdemeanors, or DWI. Fewer than 4 isn't worth anything, and the math is different for DWIs. The third component is prior juvenile adjudications. Again, 1 point. So kind of like misdemeanors, there's just 1 point possible. Fewer than, no, that's not true. But there is 1 point for 2 felony juvenile adjudications. Fewer than 2 do not contribute, and it does not apply to new offenses committed after turning 25. So this really is limited to your younger defendants. You look at the juvenile adjudications past age 25, it doesn't, it's not relevant anymore. And the final component of the criminal history score is custody status. I'm saving this to the end because it's a little bit different than the others. And in the review that we're talking about, the commission really found this to be the most interesting one. You could argue that this isn't really about criminal history. It's not historical. It's looking at the defendant's status with respect to the government and whether the government was supervising the defendant at the time the defendant committed the new offense. So not so much historical, but actually at the time the defendant committed the new offense, was the defendant under some kind of custody status? That can be probation, it can be supervised release, it could be jail or prison. So if the crime is committed in jail or prison, that would be the custody status. or on escape status when committing the new offense. Generally, custody status is worth 1 point in criminal history, but if it's a lesser custody offense, it's worth half a point. And if it's a repeat sex offense, then it's 2 points for custody status. All right, now we're going to talk about that criminal history review that the commission did in 2016 to 18. 2019 was when the changes took effect. So from 2016 to 2018, the commission reviewed that horizontal axis, the criminal history score. They found that there was a rise in criminal history from 1990 to 2013, and an even more striking fall in criminal history scores of 0. And we'll show those in a couple of slides to come here. And they found growth over time in the custody status point. We'll also show that in an upcoming slide. They also examined the decay policy. So that's the time, after time, an old offense is no longer relevant in criminal history. And they looked at that policy as well. And they looked at a study that was conducted by the Robina Institute of Criminal Law and Criminal Justice. I think that's the title. So Kelly is our chair, is the executive director of the Robina Institute, but she was not on the commission during this study. But the Robina did some analysis of the criminal history score, which was very helpful to the commission. And that study found that while the criminal history score predicted recidivism moderately well, and I should say, it's not necessarily the job of the criminal history score to predict recidivism, but that's what the Robina study looked at, was, does this predict recidivism, which is certainly interesting. And the criminal history score does predict recidivism moderately well, but some components increase presumptive sentence length without adding to the score's predictive power for recidivism. And one of those components was the custody status point. So these are the charts I was talking to you about. The commission learned that average criminal history scores have grown since 1995. So it's almost like inflation, but that doesn't really make sense when you're talking about criminal history scores. But for whatever reasons, those criminal history scores have really marched up. And when you look at that growth from 1.7 to 2.5, keep in mind that example of our burglar, right? Remember our burglar? That person was going to prison, or at least the guidelines presume that, because the criminal history score was 3. If it had been 2, that person would not be presumed to go to prison. So the difference between 2 points and 3 points is not just a number. It's a big deal in a particular case. It can mean the difference between being on probation and getting another chance, or going to prison. And again, we also learned that the percentage with a criminal history score of 0 has dropped. It's really gone down from where almost half of defendants had a criminal history score of 0 not that long ago, I guess, back in the late 90s, and that's gone down to just 25% in 2018. So that's a remarkable change over time. And then with respect to custody status point, let me just, this is both a data slide as well as sort of explaining how custody status works. So when people think of custody status, they might think of somebody in custody. Well, sort of, but the most common type of custody status that we see in the real world on sentencing worksheets is probation. So 78%, almost 4 out of 5 people who are on custody status, that custody status is probation. And the next most common is parole or supervised release. So the people who are actually confined, very small, only 1%. And then there's release pending sentencing, escape, and so forth. So the vast majority are some kind of non-confined custody status. And then this shows, we talked about that rise in custody status. So this is showing that by data, but this is actually broken down by race. So you can see that what this chart shows, in just about every year, that the top 2 groups that had custody status in their criminal histories were the Black group and the American Indian group. Although there looks like 2017, the white group might have passed the Black group for that year. So what came out of that review, that 2016 to 2018 review? Well, there were several sentencing guidelines changes. The commission adjusted the decay period, and then that was pretty much it. That didn't have to do with custody status. As I said, the commission seemed very interested then as now, even though it was mostly a different commission back then. They seemed very interested in custody status. So they eliminated some custody statuses. They permitted a waiver of custody statuses. That was kind of a new thing with respect to the sentencing guidelines. The judge could determine that it really wasn't necessary to count, for whatever reasons in the particular circumstances of this case, it wasn't appropriate or necessary to count custody status against this particular defendant. And this is the big one for us, created the 1/2 custody status point. So let's talk a little bit about the 1/2 custody status point. To do that, let me back up to the beginning of time, back in 1980 when the guidelines were made. Back then, everything was just 1 point. There were no fractions. It was just 1 point across the board. So if you had a murder on your record or you had a check forgery on your record, it didn't matter. If it was a felony, it was worth a point. And in 1989, the commission looked at that and said, that doesn't make any sense. We got it. Well, I don't know what they said. I wasn't there, but I'm sort of inferring this. They said that doesn't make any sense. Obviously, we should adjust this. So they said lesser felonies are going to be worth 1/2 point, then a point, 1.5, and then your murder is going to be worth 2 points. So the check forgery is going to be worth 1/2 point. The murder is going to be worth 2 points. But they didn't do anything like that for custody status at that time. But in 2019, so 20 years later, the commission kind of has the same idea about custody status. They're like, does it really make sense that somebody who's on probation for check forgery should get a point for custody status, and somebody who's on parole for murder should also get a point? So they adjusted that so that it was still worth a point for most cases, but for lesser felonies, as well as misdemeanors, gross misdemeanors, if that's what the custody status was for, it was only worth 1/2 point in criminal history. And that was so that custody status wouldn't outweigh the weight of the prior offense. So if you were on check forgery in our case, you'd only get 1/2 point for the fact of having committed the check forgery, but you get a whole point for the custody status of being on that. So the commission fixed that in 2019, or at least they tried to. And we'll get to some problems that unintended consequences with that. And that is the 1/2 custody status point problem. So it was a technical mistake, and I've long since gotten tired of saying this, but it was my fault. When I drafted the changes that the commission wanted to make, I was not aware that the rounding rule that's in the guidelines only applied to felony points, because that was the only place where partial points were possible. And so because there wasn't any rounding rule that was articulated in the 2019 changes, the 1/2 custody status point is never rounded down. But the grids aren't designed to accommodate partial points. So there was really a lot of confusion about what to do about these 1/2 points around there, even though because the grids didn't accommodate these 1/2 points. And staff just assumed they'd all be totaled up and rounded down. Pending the commission's resolution of the problem, courts are disregarding 1/2 custody status points. So remember, those custody status points, those 1/2 custody status points were designed by the commission to contribute a little bit, but contribute something to criminal history. Well, they don't contribute anything to criminal history right now as it currently stands. So there's a tension between the guidelines, which as they're written right now, as they were rewritten in 2019, the guidelines say, here's a 1/2 custody status point that's in your criminal history, and practice, which is, well, okay, that's nice, but we're not going to count it. That 1/2 custody status point has to be disregarded. So what to do about it? That's really the question. What to do about this problem that's out there? And there have been different options that have been suggested. One that was suggested last year was repeal custody status altogether. And for various reasons, it was just deemed not to make sense by a majority of the commission. But then in January, the commission reconsidered that after getting quite a bit of public comment and said, you know what, let's look for public comment. And that's one of the reasons why we have the roundtable today. So let's look at how custody status is applied. So this is our data section. So on the standard grid, there are three grids. There's the standard grid, the sex offender grid, and the drug grid, which is a lot like the standard grid, but it only applies to drug offenses. Here you see that that severity levels 4 and 7 have the largest share of custody status, with over half of the people on those severity levels having a custody status point. In fact, almost half overall of the people sentenced on the standard grid had a custody status point. And this shows the distribution by standard grid cell. The vast majority, again, are there on the 4, severity level 4. Those folks are the ones that have custody status most often. The sex offender grid. So this is really interesting because remember, there's a special custody status 2-point option for repeat sex offenders. So this not only shows you how many have the custody status point, and I should just say this is a little bit different because the standard grid counts where 1 is the least severe and 11 is the most severe. This is kind of upside down, where A is the most severe and H is the least severe. So severity level H, the least severe, had over half with custody status point, but overall, only about 30% had custody status points. And if you take out failure to register as a predatory offender, which the commission has on the sex offender grid, even though it has said it's not a sex offense, it's still put it on the sex offender grid. If you take out that offense, that goes down to just about 17% have a custody status point. So it's definitely different with, whatever your preconceptions of sex offenders are, they don't have custody status nearly as often as offenders on the standard grid and the drug offender grid. And then this last column I think is really interesting, and that's looking at how many people are getting this 2 custody status points. And the answer is not very many. So 2 custody status points means you're committing an offense on the sex offender grid, other than failure to register as a predatory offender. So you're committing a sex offense and you're on custody status for a sex offense. So say you committed a criminal sexual conduct, and now you're committing another, you're put on probation for that. Now you're committing another criminal sexual conduct. That gets you 2 custody status points under the current sentencing guidelines. Doesn't happen very often. There were 15 cases in 2019. And just very few cases on each of these, basically about 1.5 or 2% of these cases qualify for the 2 custody status point treatment. Then moving on to the drug offender grid. Oh, I'm sorry. This is the distribution on the sex offender grid. So what do you see? You see a lot of people in row H, which in 2019, row H was reserved for failure to register as a predatory offender. So that is the offense of failure to register as a predatory offender is really where you're seeing a lot of these custody status cases. Not so many in terms of numbers on the rest of the grid. Finally, we turn to the drug grid, which this is an interesting chart because you have D1, which is and D2. So these are basically D2 is your 5th degree controlled substance crime. And then D9 is your aggravated 1st degree controlled substance crime. And those are the 2 highest numbers. So D2 is about 60% and D9 is 66.7%. So, well, 2/3. There were only 9 cases of aggravated 1st degree, but they had custody status. So interesting there, the lowest and the highest severities of drug offenses had custody status most often. And then this chart shows where that's coming up in numbers. Not surprisingly, D2 is the runaway winner. That's because that's where 5th degree controlled substance is, and that's by far the most common controlled substance crime that we see. Now we're going to talk a little bit about the 3 zones of the sentencing grid to explain the next slide. So this slide doesn't contain any information, it's just explaining the next slide. So we think conceptually, and this was Professor Wright's colleague. By the way, Professor Wright's and Nate Wright's are not as far as I know, related. Just wanted to throw that out there. I've been asked twice already, Kevin, so that's why I say that. The three zones are severity. So that's where anybody is recommended prison because that offense is just so severe. Example would be first-degree aggravated robbery. Everybody who commits that offense, as far as the sentencing guidelines are concerned, is presumed to go to prison because that offense is that severe. The history zone is, well, this offense may not be that severe, but you can work your way to a presumptive prison commit if you have a high enough criminal history score. And then the mandatory minimum zone is, this isn't either a severe enough offense or this isn't an offense that's so severe that first-time offenders or low history offenders should have to go to prison. But the legislature has, or sometimes the commission has a policy that requires them to go. So that's a mandatory minimum zone. So looking at these zones in terms of custody status, we see that that history, not surprising, I guess, is the runaway winner as far as how many people have a custody status point. It's much lower for severity and the mandatory minimum than it is for the people with a criminal history, the exception being the sex grid. So this is looking at the severe violent offense list, and this is kind of in response to some of the comments that we got that you know, when it came to abolition of the custody status point altogether, this was letting repeat violent offenders off the hook. So the sentencing guidelines have a list called the severe violent offense list. Not very many of the cases. So if you look at the 17,000 cases sentenced in 2019, only 476 cases were on the severe violent offense list. Of those, about a third of them had a custody status point. So 159 out of 17,335 cases were severe violent offenses with a custody status point. And then of those 159 cases, 2 had been assigned 2 custody status points. This next slide is there's an error on this slide with the title. It correctly talks about sex offenders, but then it confuses it by talking about the severe violent offense list. That reference to the severe violent offense list was pertained to the previous slide. It doesn't pertain to this slide. And we can correct that on the internet after this meeting is over. But again, you're starting off with the same starting point, the 17,000 cases that were sentenced in 2019. Of those, 726 were sex offenses. Of those 726 cases, 121, that's 16.7%, had a custody status point. And of those 121 cases, 14 had 2 custody status points. So 14 out of 17,335 were basically people who were committing a new sex offense who were on a custody status for a sex offense. Then we look at the impact of custody status on prison sentences. Of the 2,500 executed prison sentences that included custody status in their criminal history, 401 or 16% of the presumptive commits were presumptive commits because of the custody status. But for the custody status, they would not have been presumptive commits. So 16% of those 2,500 executed prison sentences were presumptive commits due to custody status. That's shown on the left. On the right, it's comparing the average prison sentence of those that were executed. The average prison sentence was just under 41 months. Among those who would have been presumptive commits even without custody status, the average durational increase that was attributable to custody status was 3.3 months. So the left side is sort of showing you the dispositional impact, and the right side is showing you the durational impact, that 3.3 extra months caused by custody status among those folks who would have been presumptive commits with or without custody status. And the last chart is background reading, which was really more for your benefit reading ahead. So that concludes my presentation. So I think it's to you, Kevin.
Can we allow the one person who came in late to introduce himself real quick? Do you want to tell us who you are? You missed everybody else's name. I'm sorry.
Gotta be late and put on.
And you have to press the little button to put the green. Yeah.
Hello, everyone. My name is Justin Terrell. I'm the Executive Director of the Minnesota Justice Research Center. Thank you for having me.
Okay, well, hello again. I thought that maybe the first place to start is just to see if there were any particular reactions to my cousin Nate's presentation. I know that I've learned a lot from the commission's research. But before we dive into more philosophical questions, any questions or reactions or priority observations that we should start off with? Judge Newton.
To begin with, as a commission member, we've been through this meeting after meeting after meeting, and I found this to be very, very helpful even for me to see this again and present it in the way that Nate put it together. But it's a lot of data. It's a lot of stuff. And the sentencing guidelines, as a practitioner, as a person who sentences folks, it takes a while to fully understand and to comprehend all the ins and outs of the guidelines. But I think this was very, very helpful, Nate. But it's still a lot of information, but it gives you a sense of what the whole issue is that we're trying to deal with and do it in a fair and equitable manner. So.
No, I agree with that. It's Justice Moore.
Thank you, Professor Reitz. If I could ask your cousin a quick question here.
Sure.
Director Reitz, did the commission ever discuss the possibility of adding the custody status point to the rule on rounding, the felony point rule? I mean, was that a proposal that was ever discussed or advanced? I guess I don't remember talking about it.
So that in 2018, I think it was just assumed, at least from my perspective. I'm not going to say what every one of the 11 members of the commission thought, but I mean, I think we all just thought it was going to get added into it. We discovered the error a full 2 years after it got into effect. The judge pointed out to us that that's not what the guidelines say. The rounding rule is not where you think it is. And so staff advanced what we thought was a fix in 2021, right? No, 2020. We advanced a fix to that so I guess it would have been a year after they went into effect. I'm confused on the timeline, but anyway, we advanced a fix to it, and the commission did originally tentatively approve that fix, where the rounding rule would have come after everything was added up, which is frankly what I assumed the guidelines said without checking. But that ultimately did not succeed. It went to public hearing. There wasn't really any public testimony against or for it, but based on some of the commission's discussions after that, it decided not to go with that. So yes, that was proposed and discussed and ultimately rejected by the commission.
Okay, any other immediate? Okay, well, as Kelly said, I've worked with sentencing guidelines issues for decades, unbelievably. But this isn't an issue that I'm personally invested in. This is a very interesting issue that I haven't focused in on. So maybe I'm the right person to facilitate this discussion. Maybe I'm the wrong person. But as I understand the purpose of this meeting, it is to discuss in broad terms what the custody status point is for and try to move towards applications from that broader discussion. I want to applaud the Sentencing Commission, for a couple of years now for taking a second look at how criminal history in general is incorporated into the guidelines. I worked on a 15-year project for the American Law Institute on sentencing and corrections. And one of the things we had to do was study every sentencing guideline system in the country. And we realized that in most states, criminal history is a really large factor in dispositions and durations of sentences. But practically no two guideline states did it in the same way. I mean, the differences from state to state to state were enormous, quite dramatic in terms of what counts, how it counts, how big the number is, how much extra time might be on one sentence versus another for criminal history. So it really opened my eyes to the fact that there is no consensus nationally on how this should be done. There's a lot of experimentation, but there's no consensus. And so to me, it's one of the critical issues to think about or rethink for sentencing guidelines commissions. And this seems to be a particular sort of subset of issues that's difficult and hasn't received much attention. There are a few sentencing guideline systems nationwide that have no such thing as a custody status point. Most of them do, but then how it's counted and what's it applied to and what even gets you to the position of being eligible for that custody status addition to your score is different from place to place. So that tells me immediately it makes sense to think harder. There's no easy answer. There's no national consensus. There's no clear academic position or English criminal history that's going to guide us on any of this. But I thought maybe the first question I would ask is, what do people in the room see as the underlying purpose of adding a custody status consideration into the sort of accumulating criminal history score that a third or 40% or 50% of defendants are going to see at their sentencing? I mean, why is it there? Is it for punishment purposes? Is it because we think that it shows us that that person is more probably a recidivist or a dangerous recidivist of some kind? You know, I mean, I'd like to be educated in this. What's the thing? I can understand the counting of prior convictions because there's a lot of research that prior convictions correlate with risk of recidivism. Maybe not perfectly, but there's a good correlation there. But I just wonder what thoughts are around the room about the underlying reason for having these points in the first place. I mean, why is it done?
All done?
Oh, go ahead. Go ahead.
I think it's historically done because it has been commonly accepted, I think, by all guidelines and since the inception of our guidelines that a person who commits a new offense while under some form of supervision for a prior offense is more blameworthy than someone who's not under a similar form of supervision.
Okay, so that would mean it's really not for prediction. We're not trying to identify people who pose a greater risk to public safety through the use of the point. It's more blameworthiness. They just deserve.
Exactly. And to the extent it is for prediction, I thought I heard Director Wright say that although this isn't the purpose of the custody point, it is a good predictor of recidivism. Isn't that what the data shows?
So Robina studied, I mean, it's a lot easier to study something like recidivism than it is to study blameworthiness. So what Robina studied was recidivism and how the different components predicted recidivism. They found that some of the overall the criminal history score predicted recidivism moderately well, but there were some components that didn't add that much to recidivism. And one of those that didn't add that much was the custody status point. And that assumes that that's the point. And nobody's saying that necessarily is the point, but if that were the point, it doesn't do that well. It's probably not worth it.
Right. I think there's not much doubt that criminal history in terms of prior convictions has a fair amount of a predictive wallop. It may not be a perfect predictor, but it's, you can disaggregate and say, well, does the custody status add anything to the predictive value that you're already getting from the prior conviction itself? But any other views on this? Is there general agreement that this is a kind of a question of blameworthiness, that the people who are moved across the dispositional line from a suspended to an executed sentence, that group is additionally blameworthy, and so that's why they're going in rather than staying out? Or for those who are going in and getting the longer term, is that just punishment because they deserve it? Is that what the underlying reasoning is?
Isn't there some logic to, whether you call it blameworthiness, if you're on probation, you were given the opportunity to avoid going to prison, and you commit a new offense while on probation, thereby moving you across the line to a commitment status. Isn't that logical? I mean, hasn't that offender demonstrated he or she can't be counted on to avoid criminal activity, and therefore if they've moved across the line as a result, it sort of makes sense?
Yes.
I mean, I think about it from just, in a colloquial way. I think it makes sense to say, like, if there's something there where you're getting another second chance, basically, to behave correctly, although under severe supervision, that if you still behave poorly, then, you have sort of broken this contract that we've all agreed to. But I think on the other side, the reality is a lot of us are probably doing things wrong all the time, and we're just not under that extreme supervision. And so the idea that somebody could behave 100% correctly and within the bounds of these constraints, even more so, to my understanding, than we would have to do, we can not break laws, but will we attend every meeting and be there on time? Are we going to, follow curfew, et cetera? I think it's worth exploring whether or not that's actually a valid measure of whether or not somebody is blameworthy.
I don't understand, though. We're not talking about, are people getting revoked because they're not complying with probation? Are they having technical violations or meaningful violations? What we're talking about is someone who has been convicted of a new crime. So I appreciate the examples you gave, but I don't think that's what we're talking about here. We're talking about someone who's on probation, has been convicted of a new felony, which triggers guideline sentencing. So it's more so than complying with rules that maybe some of us couldn't comply with.
Yes, a comment.
My recollection of the robustness study, and I defer, but that it said that basically if someone's on probation, they're either going to violate probation within the first 3 years, or they're not going to at all, statistically. And so that's, I guess, one of my problems I have with the custody status point is if someone's given a 10-year probationary sentence, my recollection is the Robina study says that the value of really being on probation, in a sense, drops off after the 3rd year.
We've taken care of that by putting caps on probation of 5 years for most offenses. So that goes a long way to address that concern.
Commissioner Schnell.
I guess one of the things that, as I think about this, that doesn't necessarily support this is the fact that there is other ways to approach this issue. somebody who is on probation or under some level of supervision, and reoffends, engages and resentenced, the underlying sentence, that, the primary one for which they would have received the custody status point, there is a bite at the ability to take a bite at that apple. Now, I get that we oftentimes roll all this stuff together, but I think when we start talking about, just desserts and addressing issues around holding people accountable for what I did in that original underlying offense that put me in a custody status, and now a new offense, they seem distinct to me. And yet we now want to use custody status point as a mechanism to really take yet an additional potential whack at somebody when we do have the ability to hold people accountable on both the new offense and the custody status offense.
One thing I would say to that is we're not talking about adopting and imposing custody status points for the first time. It seems to me, let's call it what it is. This is a discussion about whether or not we should eliminate the custody status point altogether. And I think that's what we're talking about here. And we've always had the custody point. And I know you can say, well, just because we've always had it doesn't mean we should continue to have it. But the problem I have conceptually is if you eliminate the custody status point, you are reducing sentences all but in like 2 or 3 spots on the grids. So it may be that you're reducing sentences in terms of how much prison time is imposed, or you're reducing how much prison time is stayed, or you're causing somebody to cross the line so they're not going to prison when they otherwise would have. But at the end of the day, eliminating the custody point altogether results in sentence reductions in varying degrees. And I have a couple of problems with that. The first being, we have here a very technical problem. And we're going from, well, what are we going to do about this half point? Do we round? Do we do this? Do we do that? To the other extreme of, well, should we get rid of custody status altogether? And I question doing that, first and foremost, because with crime where it is, what we're constantly hearing is people are dissatisfied with judges because they're not imposing appropriate sentences, they're too lenient. Dissatisfied with policing because people aren't being apprehended and held accountable. Dissatisfied with charging decisions because people aren't being held accountable. It doesn't seem to me that this is the time to say, well, we're going to do something that reduces sentences. I don't see how that approach does anything to put us in the direction where people have respect for the law, will comply with the law, and hopefully will behave in a way that avoids consequences. I think sending the message that, well, on top of everything else right now, we're going to reduce consequences is the wrong message to send. And the other point I would make is this. I appreciate the work the commission did to take certain offenses that would have resulted in a full custody point and reduce them to 0.5. So we weren't piling on people. It was a good thing to do. Now we missed this. Well, I wasn't there, but we missed this piece of the rounding rule, and it's not a blame thing. It's very complicated. And the guidelines are very complicated, and people were doing the best they could to make a decision that satisfied legitimate concerns. Now, they reduced to 0.5, and now we have a court decision that says that 0.5 is not going to be counted. So what that means in the end is we have a group of offenses which instead of counting for 1 point, we're going to count for a half point. Well, now as a result of this court case, they count for nothing. So the end result is we've eliminated a whole category of offenses for which you used to receive a custody point, and now you don't as a result of this court case. So I guess my question to the group is, why isn't that good enough? We've already eliminated the custody point for all of those cases which we reduced to a half point. Why isn't that an adequate solution? Why do we need to go farther and talk about eliminating custody points for everybody? Because at this point, I've not heard any other proposal. It seems like we're going down the path of all or nothing. And we voted on that. I don't think we're going to reach consensus on that. So I think we need to be honest about our discussion today in terms of what we're trying to accomplish and why what we have now is not good enough, given that it actually does eliminate the custody point for a significant number of people.
Zimmer, I think you had a comment a few minutes ago.
Thank you. First of all, I want to say I support everything that Ms. Larkin has said. It is Ms. Larkin, right? Okay. Thank you for speaking out. I just wholeheartedly agree with everything you've said. I view this as a bit of a self-imposed problem. It was discussed that how it came about and the suggested solutions of, potentially eliminating the custody status point seem absurd. So that would be my position. But to get back to your original question, Mr. Wrights, I see the custody status point, the purpose of it, of fulfilling accountability in the system and ensuring integrity of our court system. We're talking about people that have very recently been convicted of a crime and were told, very clearly by the judge what the rules of supervision were. The system was going to give you a break here. You're going to be allowed to maintain your status in the community and you can't mess it up. And we're talking about people that messed up that very generous opportunity. And I just feel that if the system is going to maintain some integrity, you can't start weakening that. Many of us, I shouldn't speak for all of us, many of us have raised children. You know how to create a monster, right? You don't enforce any rules with your child and you're going to create a problem child. That is in effect what the system would do if we start continuing to degrade the tools that the system has in place. Thank you.
And that adds an additional consideration to, in part, I think you're saying that someone who commits a crime while on supervision is more blameworthy and needs to be held accountable. But in part, you're saying if you don't hold that person accountable, then their behavior in the future may be worse than if you do hold them accountable.
Yes, I firmly believe that. In my years in law enforcement, I saw it where particularly juveniles learn nowadays that there are very few consequences to their actions.
Mm-hmm.
And when you set a person up like that throughout life, and then they get to be an adult, and now they're facing actual real time or something that they've learned over time. Well, there's no consequences to carjacking somebody, or I think we're actually doing everybody a disservice, including the convicted person.
No, I'm just thinking as like the criminal law professor I am, that blameworthiness is an important concern throughout criminal justice. But then the idea that you might be changing future behavior for the better or for the worse. That's a separate rationale, maybe an additional rationale that needs to be discussed, responded to, whatever. Yes.
So I've been sort of taking notes as I've been listening, and there's a couple of things for me that are clear. The first is, and it goes to your original question, the choice is in this specific space. Are we using this as a predictive mechanism, or are we using this as a punishment mechanism? And I won't say accountability, because accountability comes from different spaces. It doesn't have to necessitate prison stay, for example. It doesn't have to necessitate, even time in a workhouse. Accountability can look different. And one of the things that our job is in the space of community supervision, particularly in probation, is to figure out what that looks like for that individual in a way that helps facilitate behavior change. Because what we're actually hoping for, I think, is both justice and safety. I know that there's this public safety mandate that you have, and you should have, but that should not come at the expense of justice, and I mean justice for everyone involved in this space. I mean for the victims, I mean for community, and I mean for the individual who has committed that offense. And I looked specifically at the space where we see most of these custody points having an impact, and it was level 4. Am I correct with that, Mr. Reichs? Level 4, for those of you who know the guidelines, is for non-residential burglary. That's the example that is listed for level 4, non-residential burglary. It's not crimes of violence. It's not carjackings, which are robberies, aggravated robberies. It's not residential burglaries, meaning someone's house. It is garage burglaries. It is burglaries of unoccupied structures where no one is present. It's a property offense, and I'm not suggesting that those people who are victimized in that space do not deserve accountability. When I was a teenager, my garage was broken into, had a huge impact on my father, who decided that windows no longer belonged in a garage, so he boarded them all up on his garage. Those things have an impact, but it's very different than a carjacking or a shooting or a homicide. Those aren't the things we're talking about in this space, if I am understanding it correctly. What we're talking about is a group of people who commit repeat property offenses based on where those things are landing on that grid. Does that mean we shouldn't hold those people accountable? No, not at all. But to conflate that with the crimes of violence that I keep hearing around this table is a different thing. And I think we need to be cautious as we have the conversation, to have the conversation from a place of data and knowledge based on what we're seeing in the study from Rabina, based on what we're seeing today and what it has showed us, so that we make the best decision for all of those involved. Because part of the issue with our system as a whole is that we don't also want to make people worse. And if we impose a sanction that is too severe based on the individual, based on the circumstances of that offense, based on the circumstances of that individual's history, we run the risk of making them worse. And we don't want to do that either. So my argument is, I don't know that eliminating a custody point solves the issue. What I hear a lot of is there's nuance in the offense. Perhaps there's nuance in the level of supervision. If someone commits an offense inside of one of Commissioner Schnell's institutions, should that person have a custody status point? Well, if you can't behave inside the prison, that is different than, and the level of supervision is different than someone who is on supervised release, for example. Level of supervision is different on intensive supervised release than it is on supervised release. So my argument, and from MACAC conversations, is that there should be nuance in that custody status point as well, not just in the offense.
Just, there was two things. I think, I want to be really clear that, for me, at least, some of this discussion is really not about the reduction of sentences. I get that there is the effect, but I think, when we talk about what's the reduction of sentencing and look at what the impact, if I understood what Nate's presentation was, the real impact of custody status is a variation of 3.3 additional months. Was that accurate, Nate? I think 3.3 months was roughly as I recall. And I think one of the questions that I then ask myself is that the measure of accountability that really is the difference between public safety or the lack thereof, or system accountability and the lack thereof. And again, I don't disagree that there are, having somebody who is on a custody status and having them reoffend, but again, we're not talking about the fact that there are still ways to hold them accountable for the original supervision offense and the new offense separately and distinctly. Finally, there's a part of this that I think, it's somewhat of the just desserts argument. And I was struck by this because I had never really thought about it in this way until Nate kind of talked about the sentencing grid, and you begin to say that we say that the guidelines really is grounded in the value that people who do more or more severe things or have a longer history should be held to account at a higher level. And yet we get to a point where once somebody has 6 points, it doesn't matter whether you have 60 or you have 60. And so yet, if that's the value, if the intent of this is all about the value of just desserts, then why stop at 6? I mean, it's a rhetorical question. I'm not proposing that should be the discussion today. But I do think that it's germane to think about, at least when we think about where we sit with custody status.
The comments, yes.
The other concern I have, first off, looking at the numbers in one of these slides from the links we got in the email, it looks like the predicted change would only be a drop of 1.5% prison population. So it's not like we'd be throwing the doors of like MCF Oak Park Heights wide open to the world. The other concern I have, and I say this as someone who's been a public defender for the last 15 years, is getting caught up in the system, so to speak, is something that happens, as we have seen time and time again, in a very disparate way, depending on how someone appears. And so the idea that the same action should result in the same consequence, I think we start to get some divergence when we're learning that people are on probation for reasons not simply because they have violated the law, so to speak, that there's disparate enforcement of these things depending on how you look. And so my concern would be that just, in my opinion, continues to sort of, I guess, formularize some of these less than good actions that are taking place day to day by law enforcement on the streets.
Thank you. And I'm going to try not to repeat what else has been said, but I did want to clarify something primarily for some folks who are maybe not practitioners when we're talking about the grid, and specifically at severity level 4. There are significant crimes that are ranked at severity level 4: felony domestic assault, felony strangulation, third-degree assault with substantial bodily harm, with victim under 4, criminal abuse of a vulnerable adult. So it isn't just property crimes at 4 when we're talking about that particular real estate on the grid. So we do have what I would say crimes of violence, because people who commit those crimes are not eligible to have firearms. And from my perspective, if we're looking at public safety, and we go back to the really sort of elementary principles, in my perspective, similarly situated defendants receive similar consequences. That's what's fair, that's what's neutral, that's what's predictable. So if you've got 2 persons who commit the same crime, one in Cook County, one in Wadena County, and one in Hennepin County, and they all have the same criminal history score, but only one person is subject to supervision, they're meeting with a probation agent, they have opportunity for programming and all those things, and they still commit a new crime. Amongst those defendants, the one who's on probation should not get the same consequence as the people who are not. I mean, for me, that's just really difficult to understand how that's rational and how we're treating people the same. And I think that one of the things that's happened since we started looking at all of this, and to Judge Larkin's point, we implemented a probation cap. And I would agree that not very long ago, if you were sentenced in Wadena County and you were on probation for a 10-year probation period, and somebody else committed that same offense in Hennepin County and only was on probation for 2 years, the person in Wadena was subject to that criminal history point for a longer period of time because of that probation link. That's true. But that's now changed. We've gone like this with it, and we've got some guardrails on how long probation is out there, and there is some ability to have those elongated based on a variety of things. But essentially, that probation cap has now kind of shrunk sort of how long the custody status point would otherwise apply. And so I think that, you know, this is a neutral factor. In fact, people know in advance before they commit the next crime that if they do, this is going to happen to them. And so there are choices that need to be made. And frankly, some of this is about consequence. This is about holding people accountable for what they're doing and what they're not supposed to be doing. And chances aside, if they still do something, they ought not to be treated by the person who's done what they were supposed to do. And I think to give credibility to our system as a whole, if we don't have that kind of checks and balance and credibility, I don't know why anybody would ever subscribe to doing anything in the first instance. And then I say, how are we further advancing not only public safety, but justice and what justice looks like?
Thank you. I would say a couple of things. One, I don't think it's fair to say that this is all about whether we eliminate the custody status point or not. That is not the purpose of today. Everybody was invited to brainstorm and think of different ideas that they may have to help us make an informed decision. So I don't think that that's a fair description of what this is in place for. The second thing that I would say is, yeah, logically, it would make sense if a person's on supervision and they commit another crime, da, 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 da. I get it. And at the same time, to Katherine Johnson's point, supervision looks different across the board. People are on probation to the courts. That is very different than somebody being on one-on-one supervision and having access to those resources. So we are just assuming when we say blameworthiness that everybody has this opportunity. We cannot ignore the disparities that exist for people who are getting custody status point. Those numbers are there. Black and American Indian people are getting custody status points at higher rates. We cannot ignore that. We cannot ignore the disparity across the state to access to resources. So in hindsight, we're essentially punishing, and I'm not going to use the word accountability because I also align with Katherine Johnson in that philosophy that accountability doesn't mean punishment. It means answering to, taking responsibility. Taking responsibility does not mean jail or longer sentences all the time. We also have to take into account the offenses that are here. You know, the 52%, I believe it's 52%, that are, you know, fifth-degree possessions or property crimes or, you know, some of these domestics that have addiction attached to it. Our legislation is making a lot of changes as it relates to addiction and really recognizing that addiction is a health problem. We know there's tons of research out there that first time at treatment, probably not successful. Successful for some, probably not the majority. There is a lot of research out there that says that. We cannot be surprised when we have somebody on probation who is suffering from addiction and then goes and picks up another, let's say, fifth-degree possession. Why is that surprising to anybody? We've known that. We know that treatment doesn't work right away. And we also know that longer sentences and continued punishment doesn't deter crime. We know that. There's decades of research on that. So I think that when we start seeing blameworthiness and things of that sort, we really need to come from the lens that supervision does not look the same across the board. Not everybody has access to what is needed. And disparities exist. And so, you know, I heard things such as, you know, this is a self-made problem. I'd argue it's different. The system is not working. And we have to address that.
I don't know how the custody status point fixes the system. I don't disagree with anything you've said, but you're talking about enormous problems. Eliminating the custody status point or reducing it doesn't address those problems. And I mean, to the person who gets another fifth-degree possession, isn't the fifth-degree possession one of the offenses, which would be 0.5, which now under the Court of Appeals decision is no point. So we've kind of taken those low-level offenses you're describing and as a result of a court decision, we've eliminated them from the custody status calculation. And I guess the question I have is, okay, we've talked about different things. We've talked about, okay, eliminate it altogether. Go to a half-point grid, which would truly treat similarly situated people the same. That was rejected. We now have a court decision that takes everything that would have been a 0.5 custody point and eliminates it, no point. Okay, well, what are the other options we're talking about if we're not talking about eliminating the custody status point? What are some of the other ideas people have? So I'm just not hearing them.
I'd love to hear your ideas. That's one thing I would say, but I don't.
I did give you my ideas. My ideas were go with what the court has done, which has taken all the offenses that would be a 0.5 and has now made them 0. So big win. Or go with a half-point grid. I'm open to other ideas, but I think I've given you a couple. I'm asking for other people to contribute to the discussion because, you know, we were told this isn't supposed to be a discussion about whether we want to reduce sentences or eliminate the custody status point, but I'm not hearing any other proposals.
I think I would propose, I would propose what I said earlier, which is add the nuance to the level of supervision, which means you're not just talking about the offense. Is this person incarcerated? Is that a different level of supervision than being on community supervision? Is this person on administrative probation, meaning they're not actually in contact with any probation officer, they're on probation sort of in name only, right? Those are different levels of supervision, and I think that those should be taken into account in how you assign custody point. I don't know what that looks like. I don't have the nuanced understanding of the grid itself, other than to have a basic understanding of how it works. But that to me is the thing that makes sense. It doesn't eliminate custody point. It doesn't say everything is 1. It says, well, if somebody's at Stillwater and they do something, that's different than if someone is on probation to Val and does something. That's different than someone who is on probation to the court and sort of on paper in name only.
And that's a good proposal. And I think to some extent, the guidelines already allow that because one of the things that was put into place when they reduced the custody point for certain offenses to 0.5 was a waiver provision. So it is possible for a judge in any case for any offense to make findings and rule that this person's custody status is not going to be counted against them in the particular case. And I would think that one of the things the judge would consider would be, well, what was your level of supervision? I mean, were you getting the services you needed? All of these things. So that discretionary tool is already in the guidelines. I mean, the judge can say, I'm not going to impose the custody point in this case for various reasons specific to this offense or this offender.
Which I think in my mind gets away from what I heard described earlier as part of the purpose of the commission, which is that sort of consistency space, or at least the space of that. So
well, I agree, but then the problem becomes, I hear again and again in the short time I've been on the commission is like, well, we want everybody to be treated similarly, but we don't like it when they are. I mean, so I don't know how you do that with a grid. I mean, I suppose you could go through and you could say, well, we're going to redefine what custody is. This warrants a custody point. This doesn't in the way you've described. So that's something we could consider. I was just pointing out that there is a way to have it happen that does allow for some discretion in particular cases, because I've heard complaints time and again that we're not using discretion where we should to make sure we're not over punishing certain people. And frankly, I review a lot of sentences and, you know, I see cases where it's like, well, I can't believe this guy got sent to prison straight up 60 months because he was hunting and he's not supposed to have a gun, where this guy has a gun, did an offense, and he got a downward dispositional departure. So, I mean, there's discretion out there. I would just like to see it used in a way that benefits the people that should be benefited. So it's a difficult maze.
One of the questions I have is, you know, hasn't there been, I mean, I think the 2 points for the sex offender side is a really good example. And some of the other carve-out provisions that the guidelines have put in place around, heightened levels of accountability, the ability to add additional consequences. What I'm trying to get this distinction of is the custody status point as a matter of broad scale policy. And I think to Catherine's point around nuance and trying to address nuance, I guess I start to think about this from the standpoint of all of the ways in which the policies that exist that do allow for the imposition of higher levels of blameworthiness, accountability, punishment, whatever you want to call it, don't those have the effect of allowing us to truly address nuance, hold people who represent the most significant levels of public safety to a higher degree of punishment, or impose a sentence that is going to have a deterrent effect or incapacitative effect for a longer period of time? Isn't that what we have? And I guess this is the part that, uniform policy of custody status. And then on top of that, we have the ways and the places that the system can elevate and address issues around higher levels of blameworthiness or those sorts of things. And I guess that's the part that I'm struggling with, because if we elevated those options, the options that exist, and maybe we need to tweak them for certain offense behaviors, for certain patterns. I don't know. I don't know what that looks like. But if that's the case, then I think that those would be things that seem that they would make sense. Because even you talk about this from a 5-year probation standpoint, is the person who gets a new offense in their 4.5 years into their probation sentence, equally culpable for having that reoffense and reconviction during a period of custody status as the person who is in the first 6 months of that 5-year probation term. And so I think these become some of the nuanced issues. And I guess the question is, what are, as we look at all of those options, we talked about some of them that the courts have and the system has. Are they used to the extent that they should be? And to truly kind of address the people that we are most concerned about? And if they are, or if they are or they aren't, what impact should or might that have as we think about the uniform policy of custody status as it sits today?
It sounds like, what I hear you, and I've heard you say this before, and I agree. It sounds like, well, should we eliminate custody status points and just do more to increase punishment for certain people who we would all think are more deserving of punishment? So there are ways to do that, because I think one of the other options this group discussed was making the custody status a departure factor. So not a custody point for everybody, but if you're on custody status, that would be a basis to increase your sentence through an upward departure. The problems with that approach are that requires a jury trial, and there are additional costs, and we have a backlog in district court as a result of the pandemic. So the notion of, having a jury trial to add a few months on for custody status when it's done routinely now, it doesn't seem like a wise thing to do. The other thing is, and I appreciate this, Commissioner Schnell, you talk about, we have to have separate and distinct punishment. If you commit one crime, you're on probation, you should have a punishment for that. If you commit another crime while on your probation, you should have a punishment for that. But I think, as we've discussed, the presumption is for concurrent sentences. So the person who's on probation with a state sentence gets another conviction and another sentence. 90% of those cases, they run concurrently. So there really aren't two separate punishments. So another thing we could do is talk about expanding the list for which consecutive sentences are permissible. So if you have someone on probation, they get another conviction, a judge thinks it's appropriate that their sentence should be longer because they have now 2 crimes, so they should get 2 punishments. Give the judge the ability to do consecutive sentencing
without calling it a departure, without requiring a jury trial. So there are some things that I think could be done, and we have discussed during the past year to get there to address your concerns and your valid point that there may be other ways to accomplish what we see as a valid purpose of the custody point through different sentencing mechanisms. So that's another thing we could talk about. But these things have been brought up and discussed, and they don't go anywhere.
Although in terms of the rationales we've been discussing, both punishment of the most blameworthy and to the extent that people are concerned about predicting future behavior, probably those concerns rise higher when we're talking about the more serious felony, the person offenses. So at least as I understand from reading the documents, part of the discussion has been a uniform custody status policy that is nonetheless more responsive to offense seriousness, or is also more responsive to what kind of supervision are we talking about in the first place? Is it administrative probation? Is it the 9th year of a 10-year term under old law? So those are the kind of nuances I think the guidelines commissions around the country struggle with. If there is some consensus that custody status is an important sentencing consideration in the right setting, what are those settings? Or how can that be defined and how can that be counted? One question that I have, and again, this is from the documents that I've read, if someone is found to have committed a new offense while on supervision, mostly these are probation cases, but other types, that 70-some% of probation cases, are there consequences that are visited upon them as part of that the supervision sentence that they're already serving? Do they receive a measure of meaningful punishment because they violated their probation, even before there's a conviction and new sentencing for that offense? Because I've seen that mentioned in the documents, but I just don't know what the reality is in Minnesota about the independent penalty for the violation as something that a blameworthy person is experiencing.
More often than not, the rule of thumb is if somebody is before the court with a probation violation that's tied to a new offense, no action is taken on the pending probation violation until the new offense is resolved because of Fifth Amendment concerns. And I think the rules of criminal procedure were actually rewritten to try to force or prevent courts from going forward with revocation proceedings if somebody has a new offense. I think the answer to your question is generally not. Everything with the violation gets put on hold unless somebody's held in custody because of the violation.
Judge Knutson, you?
Yeah, and Judge Larkin had previously talked about this. There are essentially, in my experience, no consequences for the violation of terms of probation. And the violation, of course, we're talking about is committing a new crime. And so that new crime and the sentence on the new crime subsumes any sentence that would have been imposed in the underlying crime or conviction that they were on probation for. So there aren't double consequences.
It wouldn't have been an immediate revocation in advance of the
You can't get an immediate revocation. County attorneys might file it, but they won't, the courts put it off until you can prove the conviction, which is the violation.
Yeah, and I think the typical practice is that the probation violation will track with the pending new offense until that disposition occurs. And so any correctional consequence that's being served as a result of the new offense because of bail conditions and that sort of thing is time that gets credited back to the probation level offense that, to Judge Larkin's point that she explained earlier, would be a concurrent consequence at the end result of the new charge being disposed of.
So there would be some credit for those towards the new sentence.
Credit for the time that they served on the probation violation and the new offense as well, concurrent.
Yeah, when they're sentenced for the.
Yes.
They also receive an immediate consequence in the sense that there's a body-only hold placed on them generally until the new offense is disposed of, without, the option of placing bail or things like that. So they, in my opinion, they do face an immediate sanction, not a formal sanction, but an informal one.
And I would agree with that, that they're held without being released. But the other part is, depending on the crime, they can get consecutive sentencing. So if it's one of the crimes, it's both of them on the consecutive list, they can get consecutive sentences. So it's not true that it's always concurrent.
I don't think I said it was always concurrent. I said it's probably concurrent 90% of the time. Maybe Nate can correct that, but the majority of the sentences are concurrent.
I would also add that in violations, usually when there is a new case, there's other violations that are with it that are more technical. So for example, if somebody gets a DWI, obviously one of the allegations is failure to abstain from alcohol use, right? And so we do see instances where people may go to the workhouse on the violation of failing to abstain before the case is resolved. And then the case gets resolved later. We've also seen instances, or I've seen instances in which it becomes part of the plea bargain. We're going to drop this case if you admit the probation violation and go on this case. So there's some of that taking place as well. But it's not uncommon to see multiple violations listed with the new offense, a technical violation being addressed with a shorter term punishment, and then having that case resolved later. But I would agree with Commissioner Ladd that the majority do take.
And I would just take this opportunity when we talk about the differences around the state. We don't have a workhouse out in Wadena County, and the bulk of the counties don't have that sort of thing. And so what happens is for those technical violations, and I would agree that they're embedded in that, they just sit there and they hang with the final disposition of the current offense. Because I will say that the courts are pretty careful about even imposing anything because you're supposing that somebody was using alcohol on an offense, that one of the elements is they're using alcohol, which triggers some constitutional issues in their new case. So we don't have out in greater Minnesota sort of a workhouse option to do intermediate sanctions. Typically people are brought in and their bail conditions are set in the new case and they're typically released pending further hearings in the new offense.
Well, if there are other comments on this question, we can go, but I was going to suggest maybe we take our break. Nate, take a 10-minute break at this point because we've all been sitting here for over an hour and a half and come back and continue. My basic scheme for this conversation was to talk about what we're trying to do with the custody status points in the first part of the discussion, and then try to move that towards implementation. Given what we're trying to do, what sorts of proposals might make sense? And at least my understanding was everything's on the table. It's not a closed discussion of just two options or options that have previously been floated. That we're brainstorming and trying to come up with ideas and perhaps persuade each other in the process. So good time to take a break. We will come back at, if I'm looking at the clock, it's 2:43. We'll come back in 10 minutes at 2:53.
Are we good in live, Nate? Okay, great. I'm gonna turn it back to you.
Okay, well, as I said, I was hoping in the last hour or so, we could talk more about particular implementation of the concerns and considerations that have been raised in the room. And, you know, I've already heard a number of things that could be packaged generally as one type of proposal versus another, or it's possible to combine different ideas. But one possibility is always just do nothing. The status quo is where we're going to stay between what the guidelines say and what the court has said. That is an option. There are additional comments about adapting or changing the idea of custody status so that it might be targeted to certain kinds of offense categories or certain offenders who are, most clearly presenting a kind of danger to the public or public safety concerns. And we've heard ideas about refining the custody status formula so that the different realities of different tiers of custody might be taken into account when we try to measure just how aberrant or worrisome is a particular kind of behavior. I haven't heard anyone in the discussion today stand for the proposition that custody status points should simply be eliminated from the guidelines, top to bottom. But Judge Larkin tells me, and I know from the documents, that there are some people who have taken that position. But there are these intermediate possibilities, which I think is the bread and butter work of a lot of sentencing commissions, of refinement. If there's a controversial subject, can it be moved in the direction of where do we have areas of consensus? Are there some people now, maybe primarily drug offenders or drug recidivists, just for example, that we're not as concerned about in terms of saying they need to be in prison longer, or they need to be the ones instead of probation that we're going to push over into prison, as opposed to a violent offender, a person offense with a real victim. And that's the kind of refinement or just tailoring of provisions like this that can be absolutely critical. But the two dimensions that I'm recalling from the earlier discussion is focusing on public safety, the people we're most worried about, and perhaps just thinking about custody status not as a generic guideline concept that's has to be applied uniformly to everyone who receives a guideline sentence, but it might be something that is uniformly applied to the more worrisome cases. Secondly, the other dimension or axis of the discussion is making distinctions among different kinds of supervision. Most of the status points, as I understand it, are received by probationers on probation, yet their experience can be very different in terms of the supervision and services and oversight that they're receiving. And I may have missed other dimensions, but that seemed to be the conversation. Status quo is one option. We could just codify what the current law is and take that as the best compromise that we can get. Some sort of refinement or tailoring of the criminal, of the custody status so that it applies only or most forcefully to the cases where we're really worried about that person, or where that person has done something, particularly blameworthy. And then all the way at the other extreme, although haven't heard that voice today, but we haven't heard from everyone, the other extreme is, should there be custody status in the criminal history score at all? Should it be something that judges consider as a matter of their discretion? If it's an aggravating factor, then you have the jury trial requirement. If it's a factor within the guidelines, as I understand it, there would be no jury trial requirement. But that's, you know, there are sort of extreme ideas, and then there's this more middle ground where it seems to me that there's tailing and incremental discussion that could be very useful. So I suppose I'm wondering what, you know, whether you agree with me that that seems to be the map, the territory of possibilities, and which among them is most promising.
Professor, I am really confused. And the reason I am confused is because you said that you had not heard anyone today talk about the elimination totally of custody status.
Well, Judge Larkin mentioned that that is, you know, something that a lot of people would like to see.
Not only is this something that people would like to see, I thought that was the subject of the public hearing that occurred in December. So to say that you haven't heard it today, do I understand that that is, well, I guess you can't talk for the commission, but I thought that was the whole purpose of the public hearing that created the need to have this roundtable, because there was a proposal from the commission to eliminate custody status. So I'm having a difficult time trying to understand why, even though we haven't heard that today, I thought that was the real possibility, because that was the position of the commission when it went to public hearing.
Right, and you know, I'm a newcomer to this process, but my understanding was that while there are many viewpoints that this could be done or that could be done, or different kinds of proposals, that nothing was really gathering a center of gravity of support or consensus, and that the purpose today was kind of just open the discussion more broadly with all options on the table.
I support that. But I do have to say, piggybacking on Mr. Small, it's like, that was the public hearing. Majority had the votes to do it. The majority, or someone in the majority, moved to table it because there was a perception that the public had been misinformed that doing this would reduce sentencing. So we needed to take a longer look at it. And that was one of the reasons we were having this, so we could get everybody at the table to talk about what it would really mean. So I'm not saying it's the only option, but I think we need to be honest and say that that's an option on the table, even though no one has said it out loud today. And if it's not an option, I'd ask the proponents to say, nope, that's not an option. We want to look at something else, but I'm not hearing that. So it may be an option, but I don't think we should assume it's not.
No, we shouldn't assume anything is not an option. Commissioner Chanel.
As it sits today, if we were using these other triggers that are available in the current guidelines, or I have no opposition to having conversations about looking at other areas where there is significant concern, or whatever that may be. But I think, you know, I think there's this widely held perception that the difference between custody status and no custody status is substantial increases in the level of sanction, accountability, punishment, and that's not the case. And as you look at it as a uniform policy, so how do we use some of the other policies that the Guidelines Commission has to hold people at the higher levels of accountability is one of the key questions for me. And I'm open to looking at, you know, this is one of the areas where we should focus more. Whatever that looks like, I don't know where that focus should be best be placed, but I'm willing to. I certainly in a place where I look at that.
Okay.
You know, to really respond to the question of like, are there places where we could refine the policy? You know, one thing that has sort of struck me since the last time our commission talked about this issue is, we have since had the presentation on the annual statistics, and it reminded me that every year, no matter how many people are sentenced for felony offenses, about 3/4 are put on probation, and only 1/4 are given a prison sentence. And that's intentional. That's the way that we've designed the guidelines, because we believe that community supervision is a more effective sanction for most of these offenses. But when you look at custody status, almost everybody who has custody status is also on probation. And that's because we have designed the guidelines to put almost everybody on probation. And we know that the research that Robina has done has been referred to earlier. I mean, I know that in Minnesota, most failures occur actually within 6 months. If they're going to happen, within 6 months, within 2 years, certainly, if they're going to happen. If you get past that 2-year point, you're much better off. What that tells us is that's where our supervision agencies really need to focus their time and attention, and that has been the crux of the reforms that have been taking place in probation within the state. But I think that at the end of the day, to me, it feels like we've created a treadmill where it's kind of inevitable that someone's going to get custody status because of the way that our guidelines are designed. So I'm not sure that supervision is the right factor to use to trigger that additional sanction. But now, let me like add a wrinkle to that, right? Because when I look at the sex offender grid and the 14 people that were convicted of a new sex offense while being on supervision for an old sex offense, well, that is a greater risk to public safety. And maybe we should treat those individuals differently. So, I guess what I'm saying is, like, I'm open to, are there people that we're more concerned about? Are there certain offenses that are more of a risk that we should be treating differently? And if so, is custody status the way to do that? Or do we have other mechanisms that we can call on? We do have enhancements in the guidelines for repeat offenders. There are enhancements in the statutes for some of these repeat offenses. So, if we could identify like where is the problem, then maybe we could sketch out the solution to that problem. But all offending is not the same to me. And, to most of us, and if, I've said this 100 times in our commission meetings, like, people who are offending based on addiction, that's a whole different issue. And I don't think that should be treated the same as people who are offending for other reasons. Because if they're offending because of addiction, that's our fault. We're not getting to them. As a state, we are not giving them the resources that they need. And not everybody is ready to deal with addiction the first time that you bring them into the system. And actually, why are we bringing them into the system to begin with? Like, why don't we have the ability to help people deal with addiction outside of the system so that they don't get pulled into offending as a way to keep that habit going? But so I think there is nuance. We've talked about it. There's nuance here, and that's what I'm trying to grapple with. Is, to me, it feels like we're using a blunt instrument to get at a concern that we have a lot more data and information about today than we did 40 years ago when the guidelines were created. And so, if there's a smaller subset of people that we really think need some sort of additional consequence, I'm open to that, but we have to talk about who they are.
Yes.
I used the phrase earlier that this has the feel of a self-imposed issue that was created. And nothing that I'm hearing is persuading me otherwise. Just 3 years ago, this very board took action to address, to reduce the custody status point to a half a point. There was an intent behind that. The board all agreed on what the intent was. There was an understanding, but it was a misunderstanding of how it would be applied. And now it feels as though the board is realizing, hey, the door is open now. We created this issue. Now let's just consider getting rid of the whole thing. As an outsider, and I'm a citizen as well as representing the center here, it doesn't have a very good feel. Again, this board took intentional action on a specific limited issue, and now it seems like they're trying to just blow it up. And the other thing, I just want to make one quick point. I've heard a number of board members say, if the custody status point was out of the picture, judges can still deal with the issue. The judge on the original probation case can go back and deal with that issue. Isn't that the point of that's the whole point of having the sentencing guidelines, is uniformity. So that one judge down in Wadena isn't having to take care of the issue because another, different from another judge. So I think that's a problematic argument for the Sentencing Guideline Commission to be using.
One thing I might just observe, having watched sentencing commissions now for 30 years or more, is one of the things I admire most about sentencing commissions, and the Minnesota Commission in particular, because you're the model for a lot of other systems in the U.S., is the ability to sort of constantly be reconsidering what sentencing policy is, and in light of data, in light of recent experience and how things might be different today than they were 3 years ago or 40 years ago. But to me, that's a real strength. The defect is that, yes, you never feel like, well, now we have reached universal truth and we know what's going on. But the ability to adapt of sentencing commissions and consider information and take the time to, think and rethink about issues is I don't know, it's something that I've admired greatly, and it gets people in the same room who represent very different constituencies and points of view and concerns and have, and that's, well, anyway, I think that's the spirit of the conversation today. Now,
Yeah, I think you're going to ask another question, so I don't want to disrupt us moving on with the conversation, but I want to respond to just a couple of things that I've heard. So one, if someone needs a proposal, I'm not on the commission, and so I don't want to overstep, but please eliminate the custody status point. I'm okay with being the public voice that asks the commission to do that. It's redundant. You're talking about, we're sitting here spending time debating how to punish people worthy, this and that. And whenever a room full of white people are talking about who's worthy of punishment, I get nervous as a Black man in America. So I feel like that should be said out loud. Tread lightly, folks. You got a bad track record. The other thing I want to say is that systems struggle to do this, but at the same time, we need to be able to hold two truths at the same time. I mean, it's in the PowerPoint, right? Like some folks, sometimes the system, we look at severity of crime and history and all the, I think Judge Larkin puts it right. It's a technical issue. We should treat it as such. And one thing I think is important when you're trying to evaluate a technical uh, uh, or evaluate anything, you want to understand like what is the intent, like what are the goals that you're actually trying to accomplish. It's unclear to me from all the weeds that we've spent our time in today what the actual goal is of the custody point beyond harsher punishment, which I'll come back to. The second thing is like, what is the process? Are we committed to a process that makes sense? And the third is, are you committed to evaluating and looking at and learning from the experience, which is what I think Director, I always call him Nate, my fault, my former colleague and neighbor, that Nate spelled out for us at the beginning. I think it's important that we take a minute to learn, to identify what we've learned from this policy: racial disparities, economic disparities, rural disparities, and which is something I hold this agency in high regard for, is where I was the executive director of the Council for Minnesotans of African Heritage, and sitting next to them, he had a better racial equity tool than I did. And so I trust that when he says that there's racial disparities. And so I think learn from what we are doing is the final thing. And then the other thing I just have to just put out there is that we talk about, in response to some of the comments around crime and whatnot, need I remind you that the current uptick in crime is a byproduct facilitated by the current criminal legal system. It's not facilitated by the reforms we are trying to put into place that aren't in place. The uptick in crime, the carjacking, and all these things are produced by the way we currently do things. And I think that and I work with Minnesota Heals, and I'm constantly at the table with a lot of people smarter than me, and it's consistent. Law enforcement kneeling on a Black man's neck for 8 minutes is what kicked off an uprising and the increase in crime that followed that. That is the system facilitating that harm. And if you want to sit here and tell me and try to pretend that the reforms and changes that we want to put in place are responsible for that, then you just haven't watched your own damn television in the last 24 hours. The last 24 hours, we can't trust anything coming out of what the police say in Minneapolis, and it puts us all at risk. That is a facilitation of harm. That is not a response to crime. And so I want to just be clear about those things. When we have this conversation, let's just be honest. What are we trying to get done? 3.3 months of extra time in a cell is not going to do anything to make my family feel better about the man who had his bail hearing today, who murdered my cousin this year. And I think that we need to get clear about that we don't care. And neither does the brother who killed my cousin. And so what are we actually trying to do? And then the final thing I'll just say is there's been mention of justice in this conversation. And I know I'm rambling, and that's why I wanted to say something before you asking this question. But punishment, I'm suspicious of anybody that is hey, let's figure out how hard we're going to punish somebody. That's the answer. Justice is not about punishment. It is supposed to be fair, equitable. It's supposed to be fair in process, equitable in how it distributes resources. I imagine folks in greater Minnesota would agree with that, right? That instead of punishment, we should be holding people accountable. Accountability, and we wrote a report on it, so feel free to visit my website. But it's about how you hold someone accountable and who you are accountable to. And then at the end of the day, the process should be restorative. It should be restorative. How are people brought back and not made whole, but just made a little bit more whole? That's what I wish we were talking about, but no, we're spending our time 3 months, 3.3 months. Let's make sure we get out of here with that. You are a room full of serious people, very smart folks, and don't disappoint me or our community who is struggling from an uprising that embarrassed our state across the entire world.
Yeah, I have a comment that might, relate to that. One of the things that Minnesota, the Sentencing Guidelines Commission here does very well, maybe better than any other state, is that when proposals are formulated to change the guidelines in some way, the commission can project with reasonable accuracy the impact on prison bed spaces down the road. And more recently, in the last 15 years, has begun to project the demographic impact, the racial impact of one kind of proposal versus another. And I guess my question for the group is how relevant a consideration should that be in the conversation we're having today? And just to particularize that, I think there's a document that the commission prepared at a sort of earlier stage of this discussion that produced projections for different options that had been on the table. And when I look at race and ethnicity as a sentencing factor, there's a particular part of those projections that always catch my eye, and I have to think about, again, I'm wondering whether this is relevant, that under the sort of current practice under the guidelines in Minnesota, the black imprisonment rate and the American Indian imprisonment rate in Minnesota are more than 10 times the white imprisonment rate. And I think everyone is concerned about that. If that's going to be the case, what's producing that? There's one table that was particularly important to me, and I think the commission has been working on it and double checking it, and it'll be available for circulation. But if there's just one proposal that may or may not be on the table to apply the custody status points only in cases in which defendants present already with a high criminal history score. That was one of the proposals and we can tinker with the proposal, but the point here is you can look at what the effects will be on racial disparities in punishment in the state based on the commission's projections for one proposal versus another. And it doesn't have to give you the answer every time, but it's an important consideration. So this proposal, as I understand it, was to limit the use of the criminal status, the custody status point, to the most severe cases and by some measures. And the impact on the white imprisonment rate, most of you may know this, but prison rates are usually measured against population. The white imprisonment rate in Minnesota is 122 people on any given day per 100,000 who are white are in prison. So that 122 is a number that I'm looking at. And if the custody status point were limited to these most severe cases, the white incarceration rate would drop by 8 points, from 122 to 114. Okay. Now let's look at the black incarceration rate. The black incarceration rate, current or at least recent data, is 1,267, more than 10 times the white rate. Okay. If this, and again, I'm just using this as an example, but if this particular proposal were adopted, the black incarceration rate would drop by 70 points. Okay, so the white incarceration rate would drop by 8 points. Black incarceration rate would drop by 70 points. And the American Indian incarceration rate, it's very similar, would drop by more than 100 points. Right, so this is the flip side of the data that Nate talked about earlier, showing the kind of racial breakdowns in the current administration of custody status points. This is sort of flipping that, and with each proposal to amend the guidelines, you can see a projection. Well, what would this do to what's now a 10-to-1 black-white disparity, which is now a 10-to-1 African-American white? What would it do? And again, just focusing on the white rate and the black rate, the white incarceration would come down by 8 points per 100,000. The black incarceration rate would come down by 71 points per 100,000. So there are racial disparities in the way things currently are playing out, which I don't even like to say this is good news, but part of that is that when you change something small, it benefits blacks, the Black community and the African-American community way out of proportion to the white community, because you're starting out with such a high rate of disparity. Okay. And, you know, numbers like this, I think, should be part of the conversation, but I don't know.
Can I ask a question?
Yes.
Do people see that as harm in this room, is my question. People recognize like how that translates to Black families in Minnesota and what that actually means. It's a real question. Like, or do you see it as a coincidence?
Yeah, I think it's a matter for the community and the public to decide how much.
But the people in this room decide what happens with this custody point. So I want to know if the folks in this room recognize harm to Black and Indigenous people in this state. Or do you see it as something else? It's a real question. I'm not in charge of the meeting, so you know.
No, but you know, I mean, for 15 years, I worked on the new model penal code for sentencing and corrections, which has been approved 5 years ago, but it's was a long process. And the new model penal code says that when a sentencing commission creates or amends its rules on criminal history, it should take certain things in particular in account, and that is that criminal history scoring tends to be a major driver of racial disparities in the system, and that should be a heavy concern. The model penal code also says that it should be a concern to the sentencing commission that criminal history scoring, at least in some cases, tends to overestimate recidivism risk. And so I think these are just calls to humility, that when a body like this thinks through the whole package, these are some real world impacts or possible misfires in a policy, and it's up to the decision makers and the discussion in the state. How much does this matter if we're taking a 10-to-1 incarceration disparity and we can produce a benefit that reduces the Black incarceration rate far more than the white incarceration rate, bringing those numbers closer? Still not close, but closer. How much a part of the debate should that be? That's for you to decide.
I'll answer you directly. I absolutely see it as harm. You know, I've had the opportunity to examine arrest rates in Minneapolis and St. Paul for the past, I looked at the period of 2017 to 2019, and 60% of the people who are arrested in both cities are Black. And I don't believe that's because Black people commit more crime. I just don't. So when you start with that disparity at the front end, it's inevitable that it's going to just keep going. And by the time they get to us, it's already baked in. And the criminal history scores, you know, reflect that, reflect what's happening earlier in the process. And, you know, we received a presentation last month from Professor Eugen, or maybe it was 2 months ago now, from Professor Eugen, that our criminal history score is going up, and we don't know why. Like, we have no idea why our criminal history score is going up. But it does have real effects on people. And the higher those scores go, the more people go to prison, not necessarily for crimes that we would say ordinarily merit prison. And so that is, I do find that concerning. And I do think that race and disparity needs to be a huge factor that we think about as we think about this policy. And so I go back to, what are we measuring? What is the point? And 3 of the 4 things in our criminal history score are direct measurements of convictions, which I can't do anything about, like they are what they are. But one of them isn't. One of them is a qualitative judgment that we've made about a circumstance when we think that somebody deserves more punishment. And that's not the same quality of factor to me as a prior offense, as the actual prior conviction. And so I do think we have room to rethink that, and it doesn't need to necessarily stay there at all, or maybe in the same form that it's ever been. And it's an opportunity for us to try to correct some of that disparity. If we take it out, we'll definitely correct some disparity. If we take it out for almost everybody, we'll correct some disparity. So yes, I see it as harm, for sure.
Thank you. And I think I would take it even one step further, that it's not just harm to the individual that we're talking about, but it really creates generational harm. I come from a family with social workers, and the reality is we are setting ourselves up for having further negative repercussions as we move forward when we have an overcorrection or we have a systemic situation. That being said, I think this is a really difficult conversation and issue. And I mean, I appreciate the conversation that's happening here. I just hope that folks recognize that not only is it harm to the person who is incarcerated, their family, their family's family, generations are impacted by what happens today and what decisions are made here today by you. And I can't even explain how many thousands of people will be impacted by this, in particular, people from BIPOC communities, but really everybody. So, yeah.
I think it would be important for this body to know that for the first time ever in 2001 and 2002 now, the BCA tracks offenses by race. In the past, it has always only been arrests. So only those that physically were arrested by police. It's important because now offenders are identified through victims. You know, a victim can report that I was robbed by, you know, a white man, a person of color, whatever, but that is being tracked. And when you look at that and you overlay it with the prison population by race, the disparities greatly disappear. I'm not saying they don't exist, but they greatly disappear. The offense by race mirrors the prison population by race. And I will back that up. I'm writing a report. At this point, it's not official, but that data does exist for the first time. And I think it's important that we compare the correct things. No doubt about it that when, as a proportion of the population, there are awful disparities. And I'm not getting into, you know, the reasons for the crimes, but I'm saying it's not a good comparison to continue in 2022 to say, look at the population proportion versus the prison population proportion. You have to look at the offender proportion.
Although I think it's also important to ask the question, what percentage of that disparity is being created in the sentencing system itself?
Thank you.
As opposed to earlier in the process in communities and policing and in the prosecution process. But, you know, all this commission can do is think about the part of it that's just the sentence, the judicial sentence and the guidelines and what impact that's going to have. And that, I think that's where the commission's numbers really hit me the hardest, that we're seeing a pretty meaningful change in disparities just because you kind of tweak the scoring a little bit. And that's all happening at sentencing. That's independent of what's happening in communities and policing and prosecution. I'm sorry, Commissioner Schnell, I think that you wanted to speak, or am I?
As a visitor, I would support. For 20 years, I have spent survivors of specifically crimes of, And our organization also wants justice for the victims and survivors that we serve, but there's high disparities. So, victim of crimes, part of their victim. We're concerned about these, the sentencing guidelines from two perspectives. The person, survivor chooses to go through. So, part the African life of a Black man, that this impacts me in both ways. I would hope that when this body is charged with addressing racial disparities, that charged lightly consider.
I wanted to just express that I am very concerned about the harm. And I think that the chair, we've discussed in our meetings about this neutrality review of our policies and the guidelines to try to address that at the level that we can. One of the things that came up earlier from Justice Moore was asking about why we didn't just do the rounding rule and apply it. So we'd add them together, add all the points together. And what I was there at the time, and what I recall is Professor Fraze came in and talked to us and explained that by doing that, we were going to increase the disparity levels. And so that was part of why we started looking at other options, because that was a really big concern. And I think that maybe answers that question, that we've been trying to look at not just this is one area, but also a lot of the policies.
Yeah, sometimes the disparity projection will show you if you do this, then the disparities will get even worse. Sometimes the projection will say, if you do this, you're actually going to reduce meaningfully the incarceration rate in disadvantaged communities. So it just needs to be in the mental space when consider, and each specific proposal can sort of be understood in part by this kind of projection. I'm pretty sure that the Minnesota Sentencing Guidelines Commission began generating projections of this kind in 2007, late 2007, and many of the members at the time had been appointed by Governor Pawlenty, and it was a different era in many ways. But the commission became, again, to my knowledge, the first in the country to decide we are going to generate this data. Whenever we can, we're going to generate the demographic disparity data because that commission was concerned about existing disparity levels. And this was at least one tool that made it hard to sweep it under the rug. It just has to be visible. It has to be thought about. It has to be debated every time the data support a projection. And again, I admire Minnesota for doing a difficult thing in that, a lot of agencies would say, oh no, we don't want that data. And that's going to create a conflagration every time there's a proposal one way or the other. But it's for you to decide how much does that matter if we get to the point where solid proposals are on the table, the commission's projections give you a lot of forewarning or foreshadowing, maybe of an unwanted result, maybe something that would be better for the state. So I'm seeing no hands, so
Just respond to something that Senator Zimmerman said real quick.
certainly.
Just from a research perspective, like looking at racial disparities, I mean, looking at crime and prison population tells me that you read FAQ on the DOC's website. I think it's important, Senator, that like you follow the end of that train of thought, that when you say Black people commit crimes and therefore they're in prison, and when you say that Black people are that there's more criminality happening in the Black community, that essentially what you are doing is justifying hundreds of years of not dog whistles, but bullhorns and nooses and dogs and all the hellfire that has been unleashed on my people. And I need you to understand that you mean to tell me with over 5 million people in this state and a population of a little under 10,000 in prison, because I can read those same FAQs, you mean to tell me that there's that many well-behaved white folks in Minnesota? I don't think you believe that. And I think that when we talk about these racial disparities, the other thing I'm concerned about is that it's that the goal all of a sudden becomes to let Black folks out of prison. It's not the goal. Like, I really want to encourage this group to, and I'll be quiet, but I really want to encourage this group to understand that the goal is to build safe communities. And we have communities that are safe all across the state. And you need to understand that my community is not. And I live in Richfield, bro. like I'm not talking about, like, the goal is not to let Black folks out of prison. Goal is to build safe communities. There's communities that are closing their police departments right now, and no one's screaming defund the police, right? Like, that is a safe community. And so we can talk more about it offline, but I really, really would encourage you. Like, I'm not trying to come at you, Senator. I just need you to understand. Citizen, sorry. I thought someone called you Senator. I was like, I've never met this brother. But I just want you to understand that that you got to be careful on that, man, because like my family is a survivor of lynching, a survivor of KKK raids in the town where we settled at for slavery. We're a survivor of Black Wall Street, like the survivor of the Great Migration. When you start talking like about Black criminality, like my ancestors roll over in their graves and they say they know what's coming next. So you got to be careful.
Okay, well, my suggestion would be in the last 15 minutes or so that we have of conversation is that perhaps we could go around the room and especially try to hear from people who haven't voiced a preference yet in terms of the general shape that you all would like to see, I mean, individually, in terms of what direction the commission and the state should take in its use of custody status points. And I think we're all, to some extent, political realists. Certainly my thinking about this subject, it always goes to where is compromise possible, what are likely real solutions that could happen in this state at this time. But I don't know that we have heard from everyone on their sense of elimination of custody status point, retention with refinements. If so, what kind of refinements are particularly attractive, status quo, or other options? Should we just go around? And given the amount of time that we have, this might not be realistic, but I hope that everyone could confine themselves just to a couple minutes, just so we get a sense of the room or a sense of the thinking in the room about what ideas people are gravitating toward. So Kelly, if you could.
Deep first. So, I was vocally in favor of eliminating custody status before. I would still vote that way. However, if somebody had a proposal on the table for a subset of offenses that they thought we needed to do something different with, I am open to hearing about that. But mostly I would support elimination.
So we're not doing popcorn style, huh? I would also support elimination. I think I moved this initially. I believe that the offenses that we really are concerned about, that we've heard about today, there's already things implemented in the guidelines that help us address those offenses. Similar to Chair Mitchell, if there are offenses that we are concerned about, I think it's important for us to be able to identify that and see if we need to add them on the severe violent offender list or things of that sort. But I do believe that the crimes in which we truly are concerned about and the safety issues, there's already things in our guidelines. And I do not believe that a lack of resources is a good reason to not do what can benefit most.
I would not support be in support of eliminating the custody status point. However, I would also say that how it would operate, or what we would call it, could look different. I think that, as an example, we have a definition statute that talks about severe violent offenses. We also have a definition for crimes of violence. We have definition of prior qualified domestic violence related offenses. And so some of those things to me seem like they're all sort of the same types of crimes, but we look at them differently and treat them differently, and they have different import. I think one of the things I've heard here, and it wasn't the first time I've heard it, and I think we're going to continue to grapple with it, is I think that how things are done around the state are vastly different for a whole bunch of reasons. And I don't mean any disrespect to my judge colleagues that are on this commission, but I do think when we sort of let a lot of this stuff up be to the discretion of judges, I think we're actually going to get sentences that are probably going to be a lot more all over the map in terms of outcomes. And I don't think that that's what we want to do either. I think we need to have some predictability and some guardrails there. And so I feel like there's a way to do this. And I will just state that my colleagues don't support any changes to the guidelines that are going to reduce sentences and accountability for folks. And that continues to be my position, but I am recognizing that there's a lot of work to be done here, not just with this, but with other parts of the policies within the guidelines and how they operate as well.
I'm for whatever's going to build safe communities across our state. I don't believe that an extra 3 months in prison is going to do anything to deter the young people I work with every day trying to keep off the street. I don't think it's going to deter the brother who killed my cousin or the other brother who killed my other cousin. I don't think any of them people care about that. And so I stand by my recommendation. I also just think there's a lot of wisdom in what you just said around making sure that we explore all options, that you all explore all options. So.
I would say I stand behind the legitimacy and the importance in the reasoning for those who advocate for repeal, but I think I arrive at a slightly different conclusion. I would rather see a solution that has specificity to allow for the various factors and whatnot, and as much as I also value, of course, public safety and would vote for anything that would bring restorative justice, as you had mentioned and whatnot. I struggle with the fact that restorative justice isn't always possible, and there are plenty of situations, especially with violent offenders, where there's just no evidence to suggest we have a good path. And I think from victim side, there is no single victim view on this, but I think those 3 months for those who have been the victim of a serious violent offense, those 3 months, while it might not seem logical, it is a part of many victims' sense of justice and faith in the criminal justice system. So I guess I, in some, would like to see something more in the middle with that specificity.
So I am wearing two hats in a lot of ways today. I have mentioned that I am here representing the Minnesota Association of Community Corrections Act counties, but I am also the director of Hennepin County's Community Corrections Department. And in that capacity, I wrote a letter to this commission supporting the elimination of the custody point 2 years ago, a year and a half ago. As the director of Hennepin County, I stand by that position. However, I will also tell you that my colleagues in Community Corrections Act counties do not universally support that. And in fact, what they support is something more nuanced, which is what you heard from me today, which is the idea that rather than just focusing on the offense that we are talking about, to also focus on the level of supervision. What does supervision look like for that individual? And that has to be a factor when you examine what a custody point should be. That is the position that MACAC is in support of, which is, I think, maybe somewhere in the middle, which may be the best way to go.
But what I've done and the statistics that I've looked at would lead me to favor of repealing custody status point. To add on to some of what some other folks have said who are in that support category, I also recognize that a lot of the offenders are also victims themselves, and that is a part of the cycle of, violence and offense that we find ourselves in, and we have to do something to break that cycle. And I've talked to offenders, and I've talked to people who have gone to prison and who have had longer sentences for various reasons. And honestly, it does not improve their outcomes. If anything, I've heard exactly the opposite, that they feel hardened. They feel that, and I don't know if it's 3 months' time that does that or if it's more, but the reality is, I think when we look at these folks as human beings and not merely as offenders, we recognize a more holistic version of that person. And I don't think we would wish that on our kids. I don't think we would wish that on our neighbors. I think we understand that what has made somebody behave in a certain way does not necessarily get fixed by additional time. And I do think our system, there are things that need to be done, absolutely. There are ways that we need to correct what our system is doing, because I hear the same things that you were talking about, people complaining about the leniency from judges, from prosecutors, et cetera. But I think the reality is, I don't know that what we have currently is going to fix it. And so for that reason, I would support removing the custody status point.
I feel that removing or degrading the effect of the custody status point would be the absolute wrong move at the wrong time. In the last 5 years in Minnesota, we've seen an increase in violent crime, murder, aggravated robbery, assault, burglary, 49% in the last 5 years. At that same time, our prison population has decreased by 30%. That's verifiable. It's DOC documents. It's a very stark chart when you map it out on Excel. It goes just like this. I'm not saying one is the cause of another. There's all kinds of reasons for it, but it would seem counterintuitive to, at a time when we have decreased our population already by 30% in prisons, we're down to number 48 in the country for incarceration rate, 132 per 100,000. The national average is 303. We are way out of whack already in this state, and to continue to debate ways that we can decrease that even more and think that that's going to help somehow, I just don't see the logic in it. It's not rhetoric to suggest, and that word rhetoric has been used in this debate, maybe not today, but leading up to it, to suggest that, maintaining the custody status point will help public safety. I don't believe that's rhetoric at all. More criminals on our streets will equate to less public safety. And if you don't believe that, there's really no way to have a logical conversation. Thank you.
Ms. Roller, I think we'll go to you.
Service programs that are providing services for survivors. Yeah. Very diverse perspective and expectation.
Really simply, I cannot do the internal judo to dismiss the disparate impact. I just thinking about some of that, I can't dismiss. And at the same time, on average, I can't see that 128 days on average is the difference between public safety or not. Again, I struggle with this because there are times when some of these folks, I just feel like it's, they disappoint, they fail, they do whatever they are, they're causing real harm. I don't want to diminish that, minimize that, but I can't wrap my head around 128 days and then the long-term, long-standing harm that is created by our policy to account for other areas side of this.
I haven't spoke much today, but as many of you guys, I wear too many hats. One of them is a peace officer. Another is a community member, a Black man, but also kind of a victim in a way. We lost our brother in a sense of shooting a few years ago. And in that sense is, even one day of justice would have helped my family out. Would have said, hey, I need that person to go to jail. Whether it's 3 months, 4 months, it makes a difference. So in that sense, I don't have 100% answer here, but when I hear things like racial disparities in the system, it is real. We do see it often. And that question is, how can we change that? Do we have an answer today? Not really. But leaving it up to the judges, as also somebody says, can kind of vary, and that can kind of create the disparities to a point. We need a scale that says, okay, I don't want to leave it up to a single person's opinion, but kind of a scale that kind of breaks it even on the whole system. So accountability is important as a police officer. And as many of my colleagues would probably say, people need to be held accountable. And in this system, kind of getting rid of it won't hold those people accountable who are committing it. But the issue now becomes that race and the disparities that come with it. And it's an issue as a Black man or as a brother to somebody or a cousin. I know how that can look when you see somebody that goes to prison for a small offense and they can't get out of that hole once they get into it, and it just turns one after another, and it creates that a cycle, and it continues on forever. Do I have an answer to say today I want to go towards one way or another? I really don't. A lot of people here brought up some good points here. And it's something that we need to work on, kind of figuring it out and kind of making sure that we get it right before we get rid of something or keep it in place. But what can we do as a commission to kind of make it at least somewhere in the middle? And it helps both the victims and the offender in a way.
Well, welcome to the Sentencing Guidelines Commission. Well, I've been kind of quiet here today myself, doing a lot more listening than talking. To me, part of the question is how do we frame the issue we're dealing with here today? Is it a so-called technical fix of a half-point custody status problem that we created, which I think Mr. Zimmer has indicated, and I think there is truth to that. It was created by the commission, and a number of us weren't on the commission at that time, I think in a good faith effort to deal with some of these concerns that are being brought forward. A good faith effort to address disparities and unfairness in the system and disproportionate sentences. But I also hear from the folks that are looking at this not just as a technical issue, but as a fundamental question of fairness in our criminal justice system, and particularly in the sentencing areas. Mr. Terrell, your comments about harm, I hear them. I mean, I come from a different community than you do. I grew up in outstate Minnesota, Rochester, you know, a community that in the 1960s and 70s was frankly 95% white. Not any longer. I mean, I presided over a court system in Nobles County. It was as diverse as any in the state. But my journey has been one of learning about things that I haven't experienced myself. And so when I hear folks talk about the effective harm on communities by disparities in the system, that's not an academic issue. That's a real issue, and that's got to be part of what we do here. If we can't look at fairness and proportionality and rationality in what we do, then I don't know what we exist for. But we also heard impassioned testimony at the public hearing from crime victims and representatives of organizations that support victims of crime. And, you know, it was gut-wrenching testimony, frankly. I don't think we can delude ourselves to believe that the custody status point is going to be the elixir that solves the problems of unfairness in the criminal justice system. But maybe it's a symptom of the problem. Maybe it's a small symptom. And if we can do something to address a small symptom, maybe that takes a step forward. I was not in favor of wholesale elimination of the custody status point because I thought it was, frankly, a disproportionate response. But I think there is wisdom in looking at this in a more nuanced way. I think the comment of the probation officer from Hennepin County here, Officer Johnson, is wise. I worked in a MACAT county for many, many years, and I heard from folks down there. And one thing that we have heard on this commission is evidence about the vast disparity in this state about resources that correctional agencies, probation agencies specifically, are receiving. Depending on where you are in this state, there is a huge amount of disparity in the amount of supervision, the amount of programming, and the amount of support that you get. And that's got to be factored in this discussion too. That may not be racial. It may be more of just a, geographic disparities, access to resources, but it could have profound consequences on indigenous communities and communities of color in outstate Minnesota, as well as in the Twin Cities area. I think Professor Wrights is getting to something when he's looking at focusing on those offenses and those offenders who I think we all could agree pose the largest potential threat to public safety, and to get away from some of the technical violations and treat treat people in a way that is proportionate to why, they are on a custody status. Somebody who's escaped from prison or escaped from supervision, that's a whole different story than somebody that's on paper being administratively supervised by a probation officer. I think we all can agree on that. And, I think this issue just cries out for some compromise that is focused on nuance and targeting those offenses and those offenders that have demonstrated to us by the nature of their crimes and their circumstances that whatever extra sentence a custody status point could bring is justified, and to reduce disparities at a lower level. And to me, looking at the data, I think that's justified, and that's the kind of solution that I would support.
It's long-winded, but it's to be expected coming from a justice of the Supreme Court. And so I'll just affirm him and go with what Justice Moore said. I am not in favor of the elimination of the custody status point. I think that's a factor that has to be considered in the issuance of a sentence. But how we do that and further analysis, I think, is obviously going to continue. There is no right answer. There's no clear solution to this issue. And you talk about, yeah, we created it, or the previous commission created it, but for a very good reason, as others have articulated, to try to achieve justice, to try to achieve equity in the application of the custody status point. At this point, I'm in favor of rounding down, but that's not an equitable solution, as we were told probably more than a year ago. So I think we have the path before us is to continued analysis of the offenses that the custody status point actually needs to be applied to, and how that is the custody status point is awarded. And to look at, as Catherine Johnson mentioned, what does that mean, the custody status point, and the nuance of that. But I certainly don't want to get into adding more guidelines and rules and all of that, and perhaps just a clear definition of this doesn't qualify. This type of supervision doesn't qualify for a status custody point, but this kind of supervision or sentence does qualify for a custody status point. So I think there's room to find eventually some solution, but I think it's something that the commission will continue to wrestle with, as we have, and history has shown that the commission will do in all of our work. So.
Well, thank you. This has been a really interesting and informative afternoon for me, and I appreciate having been invited to participate. When my association was first faced with this issue, we were faced with the issue that was of public debate, and that is elimination or not elimination. And that's what our association addressed at the public hearing in December of 2021. At that time, we were strongly opposed to the elimination of the custody status point. And we were opposed to it strongly for all the reasons that I testified about back at the public hearing. And at that time, I testified that our association was strongly in favor of the position advanced by Judge Larkin to add a half a point to all the grids. That was our position then. Having heard everything that was done today, voices that I heard today. I think that there are other ways to approach it. Of course, we would still favor Judge Larkin's proposal. But there was a lot of good conversation today. And I think that there may be other alternatives to the half point adding to the grid. However, we would still be vehemently opposed to elimination totally of custody status points. Thank you very much for inviting me.
Thanks. And I agree with many of the things that have been said here. Having been on the commission back in 2019, when we did reach this half point situation, that was part of a compromise that the commission worked on. In addition to that, as we learned in the early slides, that we also came up with the policy about the severe violent offender. And that whole package that came through trying to make some changes to the criminal history score, the decay policy, the custody status point, we agreed that we needed to make those changes. I was a proponent with other members back then to just eliminate the custody status point and to look at some other alternatives. I still do not think that custody status point should be part of criminal history. I think there's other options, there's other alternatives where that can be taken into account that will serve the same purpose. There's a lot of things already in the guidelines, policies that allow for sentence enhancements when in this situation with repeat offenders. Quite a few things that actually increase the sentences more than a custody status point does. So that said, back in 2019, we reached a compromise, and I think we've heard some really good ideas here that we can look at as some other alternatives. But I do not think that it should be included in the criminal history. One of the big reasons that for a very, very long time, it just seems like the person is being punished several times over. And I know that other people don't see that same view, but they already get the point or more than 1 point for the conviction, that the offense that they're on supervision for. There are consequences for the probation revocation, even if it's just staying in jail and not being able to be released. That's a consequence. And the disparities are so important that we try to decrease that, that it seems this is definitely one way that we can improve the guidelines to improve that situation.
What to say? First, I understand the harm. I don't know if you weren't here for introductions. My entire career as a lawyer was as a public defender in Hennepin County. I chose to lead up a juvenile division as a team leader so we could help kids and devote full-time attention to kids. And one of the things that concerned me most in juvenile court was I sometimes thought we were doing the kids a disservice because we did everything we could to make things go away without there being any pain, you know? And that's great. And that's what I would want for my child. But then what concerned me was, you know, if we're having these kids come through and there's no consequence, they don't get in trouble, everybody tries to just kind of sweep it under the rug, well, then they keep getting into trouble. And now they're 16 and they're facing certification, and now they're in adult court and they're facing prison. And so I have that background. And as a public defender, I went to my client's house. I gave them rides to and from court. I gave them clothes for court. I did everything I can to help them. And I've been in their homes and I've sat at their kitchen tables and talked with them about their kids. And I've seen their struggles, so I get it. But I just want to do something that makes it better for those folks without compromising public safety, because those folks deserve a safe community. And what I struggle with now, and I know we don't do juvenile justice here, is what we're reading in the papers are parents saying, we need some help because the kind of arrest and release isn't working with our kids. They're just getting into more and more trouble. We need help. And sort of the same thought process that juveniles go through, which is, well, nothing's really happening to me given what I'm doing, so why should I change what I'm doing? I'm just concerned that that's, a thought process that adults have as well. So do I think an extra 3.5 months is going to stop somebody from committing a crime? No. But do I necessarily think that saying, well, we're going to eliminate the criminal custody status point, which reduces sentences, does that send a message that's going to reduce crime? No. So, that's my problem. It's about the messaging. So I agree there are ways to compromise, but I think we need to be serious about community safety and not doing anything that adds to this chart that's being kept that says systems are failing us. Half the people don't like judges because of disparities, because of racial decisions. Half people don't like judges because they don't put enough people in prison. It's like everything we do has an impact. So I just want to make sure whatever we do with this doesn't send the message that there isn't accountability for one's actions. Because I think if we send that message, we're not going to see improved outcomes for people. It's not going to get any better. But I've been willing, and I think I've been at the table, and should we say you have to have 3 custody points before you get a point? Should we do it for certain offenses? Should we have just, incremental increases? I'm open to all things except complete elimination because it sends the wrong message. And at a different day and a different time where we're not faced with all the problems we have now, yeah, you might say that academically, we could eliminate the criminal custody point. But I don't think we can do it now. I think now is just going to make things worse.
Okay, well, thank you, everyone. I think we still have a public comment portion of the agenda. So this has been, I hope, a very useful discussion. I'll simply say now, and are we going to break for a few minutes? We're not going to take I simply won't use any more time, but just to say I've been honored to be a part of this. This has been a very enriching afternoon in the exchanges we've had. So thank you to the commission for inviting me, and thank you for participating.
So we do have time on the agenda for public comment. So I'd like to open it up for that in case there's anyone that needs to leave. For the commission members, I just want to make this one comment. I've actually heard multiple times in this round that people are saying there's other ways to do this. There's room for compromise, but I didn't hear like a specific suggestion as we went around the table. So we're coming back next week as a commission, and I would really task the commission members to say, so what are those specific suggestions? Because it would be really helpful to get them on the table so that we can actually talk about that. Like what, if we're scoping it by supervision, what does that look like? And it doesn't have to be like a beautiful proposal on a piece of paper. It can just be an idea at this stage. I'd really like us to talk frankly about the ideas, and I think that's what's lacking in a lot of our conversations, that people are afraid to put ideas on the table. And, I would love to hear those ideas. So that's what I would like to task the commission members with. Let's go ahead and move to public comment, and then we can do any wrap up that we made after that.
Could I just ask you, I've counted the votes. If the people who are in favor of elimination were to vote, they could do it again. So what I would like to see is those people come to the table and tell us, okay, what are they willing to agree to? Because I think I've made suggestions, I think Judge Moore's made suggestions, Judge Knudsen's made suggestions, but we need to have suggestions from everyone. You can't just say, well, I'm in favor of elimination, but if someone brings me something else, I'll consider it. Everybody has to propose something.
Commissioner Larkin, I'm not gonna accept that line of discussion anymore. We had proposals that you were supportive of and then pulled your support at the last minute. So I don't know what to do anymore unless I hear from you where you're willing to go. Of course, elimination is an option. I keep hearing people say non-elimination is an option. There are options, but I don't know what they are. And it's not my job to create the option for you so that I can consider it. So I think that the problem here is you're asking me to put an option on the table, but I'm not hearing one from you either. So unless we all bring those to the table, we're not going to have a productive discussion. That's what I'm saying. I heard a couple today. I heard let's talk about supervision level. Great. Let's talk. So I could come back next time with some ideas for how we could do that. But I want you to come back with your ideas too and tell me what they are, because that's what I've been asking for a year. What are your ideas? I've been asking, what are your ideas? Okay, all right.
I did numbers, I did charts. So we did all that and then we got to the end. It's like, well,
I'd like to move to public comment. I don't know. I don't have anything else to say. So let's move to public comment and give anyone else that's listening online or here in person an opportunity to tell us what they're thinking at this moment.
All right, thank you, Madam Chair. So for those listening in online, I would ask, so for those on your computer or on a smartphone, please raise your hand. You should have the ability to raise your hand. And I would ask staff to just raise their hand if they're listening in, just so I can tell that it's working. And if you do want to speak. Now, there are a couple of people who are online on call-in users. There's a 218 telephone number and a 612-968 telephone number. So I'm going to have to unmute you individually just to make sure that you have a chance to listen in. But we do have one person who's, and also if anybody who's here in the audience would like to make a public comment, if you just take a seat to my right as well. So we do have Lisa Walker, it looks like, has raised her hand. So I'm going to unmute Lisa at this point. All right, Lisa Walker, you are, you're in the meeting.
Hear me?
Yes.
Hi, Madam Chair and County, or excuse me, my phone's all beeping out. Thank you very much. I don't have a prepared speech to talk about. I testified before you all last December. It was a very emotional day for me. It was the first time I testified in front of anybody regarding our armed home invasion on September 3rd. Since that time, I have testified for the Justice Reinvestment Task Force, the Minnesota House, and the Minnesota Senate. And I have listened intently today, and I, as a crime victim and as a mother of a 21-year-old crime victim who is still reeling today, I'd like to remind you of just a few facts of our home invasion. This individual was days away from the completion of his supervision. Days away. He was apprehended in my vehicle after holding a gun to my daughter's forehead. Unfortunately, he was released from jail. When I contacted his office of record, they had no knowledge of his arrest. So the factors of our situation and the fact that we didn't get to this particular point of this custody status, the point of the fact is he reoffended within 2 years of a previous crime, same crime. And so we hear the statistics, 45% increase in Minneapolis alone, 45% increase. And so of that, how many of these individuals are repeat offenders? I have so much appreciation for most of what all of you said in this room today. And I believe it and I agree with it. And the problems are deep. Law enforcement, Judge Larkin, absolutely, because the message out there is you can do it. You can continue to do it. We all know that risk and reward behavior of those criminals. That individual was released from jail 4 days later. And the crime around the home of ours, you see it on the news. The University of Minnesota parent group, people are crying. And so we finished our legislative session with no public safety bills passed, none. And people like me who sit here in front of people like you and shake with our eyes filled with tears because we are so far out of our comfort zone, I ask you, what role do you all play in this? And it is critical, whether it's a technical detail or not. The message is huge. So thank you for your time today.
Sorry, the next person is Matt Majowski. Go ahead, Matt.
Thank you, Madam Chair, and all members of the round or rectangle table. I'm Matt Majowski, Dakota County Probation Officer, speaking for myself, not Dakota County. I would just like to support what was spoken today concerning considering the nuances of supervision. So I'm not going to reiterate everything, but sentencing guidelines are, created to provide some equity, some fairness, and it does not seem to be very fair or equitable when somebody who is on supervision or supervised release, curfews, seeing a probation officer multiple times in a week, have them compared to somebody who is on a 5-year probation and year 2 or 3, they completed everything and are sitting on paper. And to equate those does not seem reasonable. If the custody status point is not eliminated, as I spoke in favor of last year, then I think the sentencing guidelines can be used, the other tools that are already there. An example would be an expansion of the consecutive sentencing to allow to expand the permissive consecutive or presumptive consecutive for somebody who is on some sort of supervision. It is there for somebody who commits a crime while on supervised release. That's a presumptive consecutive sentence. However, permissive consecutive sentencing is more limited. So holding somebody accountable in that regard, may be an option without a major change to the sentencing guidelines in regards to, brand new rules and calculations. Thank you for the opportunity.
We now have 3 call-in users. I'm going to unmute them one by one. The first one, telephone number beginning 218966. You're unmuted. Do you have a comment?
Yes, hi, thank you. My name is Michelle Hipsig. I've been attending these meetings.
Can you spell your name, please, Michelle?
Sure, it's Michelle and then Hipsag. And so I just want to first off start by saying thank you all for this meeting. And they're always very informative, and it's always good to get different points of view. Thank you, Judge Larkin, for your straightforward, honest point of view in this, and I really do appreciate that. I guess, the elephant in the room is the fact of the matter that why are we having the constant repeat offenses? Now, I have reached out and spoke with multiple different individuals since the last December meeting, which I will say that during that testimony of the lady, and I'm not sure if it was the same one just now, that spoke of her 20-year-old daughter and the home invasion, I cried during it because it was heart-wrenching. I mean, honestly, where's the concern for the victims? Everybody wants to eliminate a point, but what is going on with the recidivism as to why are they doing it? I spoke with recovered addicts. I spoke with multiple felons, and all of them said the same thing was, well, if, we didn't have a problem with it, but I mean, I guess if you're breaking the law, then it becomes a problem. So that's the core problem here is why are they doing it? Why are they breaking the law again? And I do tend to agree that, I mean, people learn by certain things, for example, when you're a child, if you touch something hot, you get burnt. Oh, I'm not going to touch it again. That example was pointed out to me by a probation officer that I spoke with about this. And yes, that's very true. So if we just say no, and just keep rewarding bad behavior, where's that going to get us? Our crime rates are high. People in Minnesota are tired and they're fed up with this. And it's going to affect, things in the polls. I will tell you, because they've had enough. I mean, I brought up before looking at different programs because yes, it's true. So if they sit in jail for, 20 months or whatever, and then there's nothing going on to do something to curb the behavior while they're in there, they're going to get out and it's just going to be the same, because if that's the definition of madness, you just keep repeating the same thing, I guess. But I mean, so maybe there does need to be a change with programs while incarceration. I mean, I saw a thing where there was meth getting brought into the prisons. I mean, this is a very large problem of many factors, and you can't possibly address them all today, and that's understandable. But to just hear that, well, we just have to do this because of, and I'm not against any, race. I'm from a multiracial family, but my family isn't in jail because they're not breaking the law. So why is it happening? And it's your guys' job to enforce this, to serve and protect. And, the county attorneys are tired, our officers are tired, and your constituents are tired. So I'm not in favor of this decreasing of the point system. I agree it's going to set a bad precedent, but I do think there needs to be some things looked at as far as to why are we having this? What is going on? Where's the break in the system? You have to get to the root instead of just putting a Band-Aid or what you think is a Band-Aid on the situation, because that's not an optimal thing. I guess, I didn't have a speech prepared, so I'm sure I would have a lot more to say, but I know I have talked to many, many, many people in all aspects, and I haven't heard anybody in favor of such a thing. And even the ex-cons that I spoke with said, well, there's programs. It's just basically a choice, do you want to change or do you not want to change? So, Honzi, Tanya, you were wanting and advocating this, and you're attacking Judge Larkin. What is your method to fixing this rather than just dropping the point? Thank you.
Thank you, Michelle. We have two more call-in Well, now one disappeared. So now apparently we have one. It's telephone number 612-224. You're unmuted. Do you have a comment for the roundtable?
Yes, yes, I do have a comment. Can you hear me?
Yes.
Yes, this is Jacqueline Williams. I'm an attorney, citizen. I've been following what the Sentencing Guidelines Commission has been doing since last year. And, you know, I think I see that it's a struggle. But I do think that Judge Larkin has it right, that public safety has to be a priority, and eliminating the custody status point at this time is sending the wrong message at the wrong time. There are disparities. We can deal with them in other ways. Perhaps not connected to the criminal justice system, you know, social workers, things like that. And then I heard two strong, clear, simple proposals today. So I reject that there haven't been any proposals. Judge Larkin suggested adding a half point to all the grids. Why not? Talk about that. Why not do that? And then Judge Knutson said he was not in favor of adding another rule, or another guideline, whatever. But he said, let's just have a rule. This type of supervision qualifies. This type doesn't. That seems simple. Why can't that be a starting point? And I think, you know, in that discussion around Judge Knutson's point, there is nuance. People mentioned nuance many times today. So there is room for nuance, but I don't think hyperbole helps. We need to focus and be clear-minded, and it's hard for me to speak publicly, but thank you.
Thank you, Jacqueline. Madam Chair, that concludes all the raised hands and call-in users. That should be the end of the public comment.
Excellent. I just wanted to ask Professor Wrights if there's any wrap-up thoughts that you want to offer. If you don't, that's fine. It's up to you.
I think I felt that the exercise of going around the room was about the best wrap-up we could have had in terms of understanding people's thinking, and the complexity of the issue came out throughout the day. So I don't want to keep people here longer. They don't need to hear me orate, and I just thought it was a very, very useful session today, and I hope it spawns some movement and some compromise.
Well, I just want to thank Professor Wrights for agreeing to do the roundtable today, to be our moderator today. I want to thank everyone who came, and I wish I had done that before someone had to leave. We ran a little over, but I really appreciate the additional voices that we had at the table today. And I want to thank all the commission members, because I do think that it was a very good conversation. I think we have like the germs of some ideas that we could potentially talk about next week, and I hope that we will have a productive discussion then. I'm not going to hold you any longer either. Thanks again. The meeting is adjourned, and I'll see the commission next week.